Apologies, there are none. Confirmation of agenda. I'm happy to move that the agenda be confirmed. Seconded Mike. Any discussion, debate? I'll put it all in favour, please say aye.
Aye.
Against?
Someone else was going to speak.
Sorry, I was not aware of that. I've been advised, and certainly the GSO hasn't been advised, sorry.
I had booked this.
Well, I'm sorry, we haven't been told. Who did you speak to?
I don't know exactly. A governance officer. It was some time ago.
There was an issue where I did I speak to you on the phone?
You did.
And sorry, you indicated that you no longer wanted to speak with you by what I understood. Sorry.
I see. I wanted to think about it.
I'm going to take the, it isn't on our list. I'm going to take, we have moved past that item, but are you happy to go back into public forum? Someone's turned up with the expectation.
No.
You've spoken already to public forum, haven't you?
Yes.
Yeah. So look, we have gone over time for public forum. I don't think we're going to get there today.
She provided what she's written to me after. I'm giving a code now.
Thank you, that'd be fantastic. It'll alleviate that issue. Thank you. I'm sorry about that. I had understood that you wanted to withdraw Albert 1, you know. The declaration of interest, I'll just bring it to your attention and note it. Naming of new road in Portugal. Bruce, welcome. Lancaster Lane.
Good afternoon.
Well, do you want to speak to this report?
It's actually a very straightforward report. Absolutely meets
The criteria.
the criteria.
Councillor McTavish has indicated she's happy to move. Councillor Staines is seconding. Any discussion or questions?
Well, it's a question really. If it complies with the policy, why are we making a decision on it?
We still have to. It's not delegated because that's our role.
Madam Chair, I'm not wanting to cause a debate on the issue because I don't think we're going to have one, but reading the conclusion, it meets the essential criteria. I'm not sure whether it meets all the criteria. It would have to be an exceptional name to meet all the criteria. Sorry, I just wanted to point that out.
I have no idea why you would want to point that out to Councillor. No. If there's no other debate to add to this particular matter, I'll put the motion. All in favour, please say aye.
Aye.
Against? Carried. Thank you. Jared, welcome to the table. Under our standing orders, community board chairs are allowed to appoint us and have rights to ask questions and, my understanding, and to speak, but they do not vote. I think that's standing orders to put it. So that's why I've got Jared around the table today. Yes, Richard.
The question about process, how do we have this debate in the complete absence of being able to ask questions about the legal opinion?
I think we'll bring this up to the table.
Well, could I move that we do waive privilege? Because it seems to me it'll be a nonsense if we can't refer and ask questions of the lawyer in open session.
Can I just check that the lawyer's happy with it? Yes. Seconded, Aaron. Oh. Any discussion? Sorry, is that both opinion? I think that the grey papers you're talking about?
Yes.
All grey papers? Yep. Any advice you want to give us on that, Sandy, first?
If you're happy to consider them private, then that's fine. It's an option.
Okay. Well, I'm going to put the motion. We all understand what it is to take the papers out of grey paper into the public. All in favour, please say aye.
Aye.
Against? Carried. Thank you. Ask you to join us. Thank you, Jane. Hello, gentlemen. Now,
Good afternoon.
Jane, do you want to talk to the reporter first, or self-explanatory?
Not in great detail. I think everyone's very familiar with this situation and this matter, and just really, I think, open to questions at this stage.
Just a matter of form. Sandy, we're going to have those other papers sooner than later? Just the non-public forum ones. They'll be here soon.
I'm sorry, I don't have to read. Well, you said you would.
No,
Copy from the lady. Someone's off doing it, it's just a single page, but she wanted to make some edits.
okay, sorry. It's just, sorry, the non, as in they didn't make it to public forum, but I want them to be here before we decide, sorry. Okay. Michael, do you want to say anything to your report or anything you've heard today so far?
Thank you, Madam Chair. The first thing I'll just say is consistent with your resolution to waive privilege. I'll just answer freely and openly in terms of my opinion without regard to the public. So I'll just give you my legal view as if I would in private. There's nothing I want to add other than just to summarise the legal position. As we see it is that this is legal road. There is a common law right to pass across it, including with vehicles, in our view, and that council is only entitled to restrict that right by going through some lawful process, and we've outlined in our letter the options available to you. If you're looking to permanently restrict the use of vehicles along this legal road, we've outlined that the most appropriate approach is by bylaw, and you need to, if you're going to go down that path, justify it based on safety grounds, as you've heard from the community. And the only thing I'd add, which I did outline in my letter, is you need to be satisfied ultimately, if you're going to pass a bylaw, that the safety issue that does exist does justify the restriction to prevent vehicles completely, compared to other less onerous options such as road improvements, signage and the like, which might be available to manage the safety risk without going to the extreme of preventing vehicles completely. So that's really, that encapsulates the legal side of things.
Okay, and we're going to take questions of either Jean or Michael now. First up is Aaron, then Lou.
Thank you. My question is for Mr. Olorenshaw. In preparing this report that's before us now, were you aware of the concerns raised by the Department of Conservation and others around the New Zealand Coastal Policy Statement and our potential obligations under that?
Yes, we were aware of those letters, and they've been included in the pack that's been circulated.
The letters have been included?
Yes.
But there was no reference to them in considering your recommendations?
No, I suppose the recommendations are based on the previous resolution from the committee, and that the approach we've taken here is that the committee is to consider this additional information that's been provided.
And so at no stage did you seek advice from planning staff or legal opinion specifically with regards to our obligations under the New Zealand Coastal Policy Statement?
No. We took it as it stood, that there is obligations under those policies.
Thank you.
Hillary?
Two questions, one for you, Mr. Olorenshaw. On speaking with DOC, they seemed clear that we needed to watch over the environment in an estuarial situation such as we have, whenever there is any access points to it under the coastal plan. Is that what your understanding was? You know, such as that since we've got a variety of points, access points to this estuary, we would still have obligations to be thinking about it, regardless of whether this particular access point was there or not there?
Yes, it is a consideration. I think that's your question.
It's sort of separately to this access point, but it's a consideration because of having any access points to the estuaries. You know, we would have to be watching over it.
It is a policy, it's government policy that we have to be mindful of, and we don't want to be doing a position where we're doing things that are untoward or go against those policies.
And a question for Mr. Garbutt. If we were minded to follow the recommendations in this paper apart from possibly 3, since I'm not sure what courses of actions were being proposed there, so maybe you can't comment on them. But the first 2, would they fit with your legal advice? Would it be that if we took that course of action, it would be an appropriate legal thing to do?
Yes, from a legal point of view, I have absolutely no concerns with 1 and 2 in terms of removing the rocks. That puts the position back into, from my point of view, conformity with your legal obligations. The problem legally arose when the rocks were put there in the first place, impeding the right to pass along the legal road. So by removing that, it brings things back into legal compliance as far as I'm concerned. So yes, I think that's consistent with my legal view.
And number 2?
The same, yes. So that's that's just saying that there'll be a report prepared in mid-2005. There's no problem with that at all.
But so that sort of fits in with your, if you're even mindful of thinking about any other long-term options, you would start with that. But is it?
Yes,
Just to fit in with our legal things, if we would.
Yes. What 2 doesn't say is it just says that the report will be produced to Council mid-2015. I presume the intent behind that, but I don't know, is that monitoring will occur to determine how the road is actually functioning, and presumably if there is in fact a problem, then that will be a basis to promote bylaw, potentially addressing the actual issue that has arisen during that monitoring period.
Number 3?
Well, I don't know what number 3 means.
Thought somebody might.
Perhaps I'll just try and elaborate. So, recommendation 1 and 2 was stemming from the earlier resolutions, which there was a suggestion that the rocks removed and some minor works undertaken, and that this monitoring carried out. So that's a reflection of that resolution. Item 3 is a reflection of the additional information coming to hand since that time that you may want to consider in light of the situation, whether you want to make an alternative resolution.
Thank you. Andrew.
Thanks, Madam Chair. My question firstly is for Mr Garbutt. If we were to formalise the stopping of the paper road, and we were to use, as Mr Doherty suggested, an Esplanade reserve process under the RMA, from a public consultation point of view, does that involve a similar consultation process? And the question around that is it a special consultation process because it's under the RMA? It's not required to follow that process, is it, or not?
Yes, I read with interest what Mr Doherty was saying about the Esplanade Reserve, but I don't think it's the right process here, with all due respect to him. What the section in the RMA he was talking about is it enables council to put rules in your district plan that when subdivision occurs, you can require Esplanade reserves adjacent to the coast. So all that would be doing is putting rules in the plan to say if somebody subdivides beside the coast here, they're required to provide an Esplanade reserve. It doesn't address legal road status. I think it's the wrong path to go down. The issue is, you have a legal road, does it remain in what form, or is it stopped? I think that's a Local Government Act issue. It's quite removed from the RMA issue.
The second question, Madam Chair, was around vehicle use in its current form. In a legal sense, does it make any difference that a motorised bike, i.e. a two-wheeler motorbike, can actually physically use the paper road in its current form? Does that make any difference in a legal sense?
The legal position in terms of this road and all others in the district is that the common law really tells us that you're entitled to pass and repass, and at the moment you can physically do that with, as you say, motorbikes, walking, horses and the like, which is fine. The impediment of the rocks precludes the vehicles, and in my assessment that is the obstruction that council has created, which is effectively, in my view, unlawful. So just by saying that people can take a motorbike or walk as an alternate doesn't address the issue that you have effectively precluded someone's right to take a vehicle down that. So just because there are alternates, it doesn't fully address the issue. You're still impeding on people's common law rights in the way you're wrong with.
And the last question, Madam Chair, is around the actual term that the road has been unofficially closed with 2 rocks at one end of it, and where you can physically drive on 99.9% of it.
Yep.
Any opinion on that?
It comes down to ultimately that council has taken steps to put the rocks in place in the first place. That is the action that council has taken here to cause the impediment, which is the problem. So if the obstruction was purely natural due to a slip or erosion, the situation would be different. But by having taken the step of creating an impediment, that has been done by not following the correct legal process, causing the impediment to the common right to pass. So,
okay. Can I ask one more question, Madam Chair? Just arises from that answer. So if the rocks were actually sitting on either Bank or Bay Road and not actually sitting on the so-called paper road in question, in a legal sense, is the road closed or not? Sorry to ask that.
Yeah, look, I don't quite understand what you mean.
Well, okay, if the rocks are physically sitting on what is deemed either Bank or Bay Road, so in other words, on the edge, let's say they're right on the carriageway. No, I know they're not, but let's say they're very close to the carriageway, so they're actually in the legally identified Bank and Bay Road area. So does that mean that the paper road in question hasn't been closed?
Well, we're talking about creating an impediment to people's rights. So, you know, if you move the rocks around so that people can freely pass, then it's not an issue. But that's not what you're dealing with.
Okay. Thank you.
Okay, next up is Richard.
My questions are to Jean. The 6 months monitoring, what would that involve, and what are the criteria that you would be monitoring against that would enable you to report back in 6 months to tell us what should or shouldn't happen?
It's predominantly safety orientated and use of the track.
Yes, like, so what? What are the criteria?
We haven't been explicit because we haven't confirmed the exact criteria.
But whatever they are, 6 months is a magic number that would enable you to draw a conclusion.
I think from memory that was the resolution.
That was the resolution of council.
Well, I'll ask you, is 6 months an appropriate time period from which you could draw a conclusion?
You'd certainly, depending on what happened in that 6 months, I suppose, get a view of what the situation is.
So, would you consider that State Highway 1 is a dangerous place for cyclists, given that nobody's been killed there in the last 6 months?
Not sure of the relevance of the question, but I think what you might be asking is around the level of risk that's presented rather than an occurrence of an actual event. Just because an event hasn't, or an accident hasn't happened, doesn't mean that the risk isn't still present.
Well, quite. So I'll go back to my question. What are the criteria that are going to enable you to make a statement about risk in a 6 month period that would leave me feeling comfortable that this is a safe thing to do?
We haven't established the criteria at this stage to do that assessment.
So would you think that that might make people feel just a little uncomfortable?
No, I don't, because we would be applying a professional judgment and professional practices to the situation to establish the criteria that we would apply.
So in essence, it's a little bit like deciding whether somebody's a witch or not. You've actually got to drown to prove you're innocent. We don't get the prize here till somebody gets hurt.
Through Madam Chair, as what we've tried to do is to, in accordance with the previous committee resolution, which sought to open the road and have it for a 6-month monitoring period, to have some monitoring regime in place that will tell us hopefully what might be happening there, but it's no more defined than that. By opening the road, given the advice we've been given, there is an inherent risk, and all we can do is monitor in accordance with the resolution.
Well, I'll withdraw the last question. But a completely different question. The focus here has largely been around safety issues, and that seems to also be what is going to be monitored over the next 6 months. But are there reasons around the impact on the estuary that would, in your view, be relevant to any decision that might be made, regardless of whether or not legally we're obliged to remove the rocks in the first instance?
In my opinion, putting safety aside, I think, yes, there is considerations around the estuary. I think that's apparent that there's concerns from the community in that regard.
John.
Yeah, Mr. Garrett, I've always understood that local authorities were not allowed to break the law. If you have a local authority that knowingly breaks the law, what are the possible or likely consequences of that?
Well, addressing that question in relation to this issue, someone could go to the court and seek a mandatory injunction requiring removal of the rocks, and their costs is probably the most obvious legal action here to force council to put back the position in terms of its legal compliance. The other slightly softer options that always exist to go to the audit to general, complain, public statements and the like, bring the usual public pressure to bear on the elected members.
That's not too bad, thank you.
Thank you. Gingy? Stuart.
Thank you, Madam Chair. I have a few questions. I think most of them are for Mr. Garbutt. The first is just to clarify, a road is deemed a road by the district plan, is that correct?
No, the district plan just, as it does up there, just shows you where the legal roads actually are. The creation of a road comes via a variety of methods.
Okay. But as you state in your legal opinion, the management of roads is governed by common law and statute, primarily the Local Government Act.
That's right.
But the Land Transport Act is the one that governs the potential closure by way of bylaw.
That's right, yes.
Okay, thank you for that. Can you explain or give some comment on the relationship between this council's relative requirements under the New Zealand Coastal Policy Statement, giving effect to the regional policy statement and giving effect to our own district plan provisions when making decisions about the management of a road under the Land Transport Act?
Yeah. The way I would answer that, Councillor, is to say to you that the road legislation such as the Transport Act and the Local Government Act have very clear and prescriptive procedures for how you go about restricting or closing roads. The criteria in there are self-contained and very prescriptive and are not influenced by whatever is in the coastal policy statement. Or put another way, just because a coastal policy statement says that you should respect access to the coast or preserve natural features in the coast, that doesn't give you the arbitrary ability to put barriers on a legal road. So while they're relevant considerations when you make a decision, they don't give you powers to curtail existing legal rights.
So they are factors when making a decision as to whether or not it is appropriate to close a road,
Yes.
but they do not give us the mechanism by which to close the road.
Absolutely, yes.
Thank you. That one. So, in relation relation to the question that was asked of you by Councillor Calvert in terms of the recommendations 1 and 2 and your legal, and whether or not they're consistent with the legal opinion that you've given us, I'm curious as to whether the alternative course of action recommended by staff in the previous report, which was to temporarily close the road and then undertake a process whilst it was temporarily closed to either make an assessment as to whether or not it can be made safe or permanently close the road by way of a bylaw. Are you comfortable that that alternative approach was also consistent with your legal opinion?
What I can say is you do have the power to temporarily restrict vehicle access. It's got to be based on some rational basis, and here it would have to be based on safety. So you've been needing to be satisfied that the safety issue does justify restricting vehicles. And the second criteria is that it's got to be temporary. And then the whole issue is, well, what is a temporary diversion of traffic? So I am comfortable that you could temporarily divert traffic based on an actual safety issue, but that is for a limited period of time. So I wouldn't say it's entirely consistent. It's on those caveats that if you tick off, yes, we have an immediate safety issue, yes, we want a temporary diversion of traffic, so that you can put something in place more long term within that temporary restriction. I'd be satisfied you could do that.
And which clause or statute is it that governs the temporary closure?
So that's clause 11 of the 10th schedule to the Local Government Act 74.
Thank you. And safety, immediate safety issues is the only environmental considerations are not an issue under that clause that can be cited as a reason to temporarily close the road.
Yeah, what it actually says is that so you may, subject to consulting with the police and the Ministry of Transport, close the road to all or parts of traffic. And there's a range of reasons which here are largely irrelevant, except there's one which might be relevant, D, when for any reason it's considered desirable that traffic should be temporarily diverted to other roads. And so you're exercising there a power to, as I said, curtail someone's otherwise legal rights to use the road. So you've got to, in my view, point to some valid reason why you're impinging on those rights temporarily.
Thank you. I have just two more questions, Madam Chair. In relation to deeming whether safety concerns exist in a given location, is what factors are taken into account when deeming whether or not a safety concern exists? Is it only the existence of a crash record, or are there other factors that can be considered?
I would comment on that. It all depends on the evidence that you have, and the only evidence I've seen is the report from Mr. Minima, who is a traffic engineer expert in this area, and so it's a question of assessing all the evidence that you have and to form that judgment. Here you don't have a track record of use because vehicles have been prohibited from its use. So all you can go on essentially is the advice of experts and the other community members. So you need to take all that into account and weigh up the advice you've been given on safety issues.
Okay, and my final question is, it pertains to, I hope I get this right, the Land Transport Act, Clause 22 AB1G, which is the bylaw provision, and the different, and you make some comment in your legal opinion as to the different limbs of that, one being safety, one being environment. Clearly there are some questions as to whether or not, given the length of time that has ensued since temporary illegal closure of the road, and now there are some concerns or questions around whether or not we have evidence base under the safety limb of that. In relation to the environment limb of that, we have evidence in front of us today as to the significance of the eelgrass habitat from DOC. We have comment from local iwi by way of the Taipure Committee with raising significant concerns. We have cited information from local ornithologists, local ecologists, members of the community who raise concern about disturbance. We have a history of concerns that have been flagged with our staff since 2006, 2008 or something. We also have a body of policy, which is district plan, regional policy statement, New Zealand coastal policy statement. Given all of this and the local awareness of the habitat in terms of this being the only patch in the wider area, is there sufficient evidence to commence, as of tomorrow, the development of a bylaw under the environment limb of that LTA clause 22, section AB 1G, even in the absence of a crash record involving traffic concerns?
Well, I'm not sure if that's actually a legal question or a policy one, but from my point of view, you're not being asked today to approve a bylaw. The creation of a bylaw involves, I think, instructions to staff to go away and investigate all those matters and get proper reports done on ecological and safety issues, and then to draft a bylaw and come back to council, and for council to decide at that point whether the council is satisfied that there is sufficient evidence to justify the type of restriction being proposed. So that's the part I would commend to you if you are thinking about going down the bylaw path. But you're a mile off deciding that at the moment.
Thank you.
Jared, I've got enough councillors still to go. I'm sorry, and I'm going to take the everyone first one before I go to seconds.
Thank you, Madam Chair. First of all, a couple of questions for Jean. Jean, in the proposed changes that you're suggesting a 4 metre wide width between the barriers for vehicle access.
Page 5.7.
Could you please maybe explain why you've chosen on 4 metres?
So the proposed works are conceptual, they're not detailed design at this stage, they're just for the purpose of demonstrating the solution that's arisen from a site visit by a number of staff. The 4 metres and the tapering of the site rails is there for the purpose of vehicle turning, so that as vehicles come down Bay or Bay Road in particular, they turn left into it so that they can access the track in a safe manner, rather than taking an extreme case of turning a 90-degree angle and entering down the track. So it's for essentially safe turning circles.
So just with the safe turning circles that you're proposing, they will effectively cover what is the formed footpath accessible or not to a much larger extent?
Yes, they would. The vehicles would, as they pull off the sealed carriageway, would pass over the the footpath to cross into the track.
When council were on site, and you were there as well, Jean, it was observed a number of vehicles using this particular corner, and a number of them traversed across the centre line. In your view, would vehicles travelling in opposite directions, requiring one to move across to the left heading up the page, allow a pedestrian sufficient space to get out of the way with the barriers in place?
So just to clarify your question, a scenario of two vehicles passing at the same point,
correct,
and the width that is there. The barrier at this proposed site rail is on the outer limit of the footpath at the moment. So, and to give a definitive answer, we would need to check those dimensions to see whether there is adequately safe passing. But it is, I think, acknowledged that it is a narrow corner, and we had, at the site visit, there was vehicles passing over the centre line. So I think that safety risk there is acknowledged, but would need a bit more detail, and that would be worked through during a detailed design phase.
One further for you, Jean. In your professional opinion, is this intersection safer with or without the rocks?
In my professional opinion, and I would prefer that Ron was here to ask that, because I'm pretty sure to give a similar answer as our safety engineer. It would be safer with the rocks.
Now, just a couple for Michael. Michael, sorry, Mr. Garber. When you reached your view about the common law right of motor vehicles to use roads, did you consider the Brader vs Ministry of Transport 1981 case under the New Zealand Court of Appeal?
Sorry, what's the name?
If you need to get appreciating your report came from not just yourself but also associate, if you wanted time, I'm happy to take a break to confirm that.
Madam Chair, I'd be happy for just, he's not sure.
You know,
No,
I think
I'll answer your question. I haven't looked at it. I'm just reading the actual summary of it. It's just, I would like to check it, but I don't think it changes anything. It's just saying you haven't got an absolute right to use a vehicle on the road because there can be restrictions on your use, such as what we know. So I'm familiar with the concept. I don't think it's going to change anything, but I haven't specifically looked at it as the answer to your question.
And just one final one.
But sorry, I will add to that though. The Court of Appeal decision we had cited did specifically say there is a right to pass and pass with vehicles on legal roads. So that's talking about a different issue, I think.
Thank you.
And just one further question. In relation to your recommendation to bylaw, as opposed to changing the status of the road, what other land statuses could be chosen other than Esplanade Strip Reserve?
Yeah, okay. No, that's, at the moment you've got legal road and it either stays legal road and you restrict the use of it, or the only other way is to physically and legally stop it as legal road so that you go through a formal road stopping process and then the status of road disappears. That is a formal public process that then would preclude all use of the road, such as pedestrians and the like, which I haven't even gone into because I don't think anyone's suggesting that is.
We're dealing with that in the next matter on the agenda.
Right, the road stopping, yes.
Just follow up. Once the road is stopped, however, surely council will be in a position to seek to have an alternative status put on the land.
Well, if you stopped it as legal road, council could decide what it does with the land then. Yes, that's correct. But I don't want to give the impression that a road stopping is actually easy or available here, because it is actually quite a difficult thing to justify stopping every public use of a legal road, where here there is a consistent and common use of it. So I don't actually think we would get it stopped, frankly.
And, sorry, one last one.
I'll believe you next time.
With the other legal roads that are around the city, and a good number of them have other physical impediments, and I'm not suggesting council placed them all, I'm certainly aware of one or two where they placed some. Does this pose an issue for landowners such as farmers and the like, where they've quietly enjoyed the use of those legal roads in the absence of vehicles? Should other parties come to council and say, we don't like that impediment?
You're raising issues of precedent, and look, the issue doesn't change. If there's a legal road on somebody's farm today that they've fenced, Ultimately, council could come along and ask them to remove it today as they could tomorrow. I don't think this changes anything to do with the legal status. That would be my response to that.
Thank you. Lee.
Thank you for answering so many questions today. I'd like to return to the recommendations, and particularly number 3, which I have a difficulty in understanding. Number 3 says instruct officers to take any additional or alternative course of action in response to the additional information received. Question for Mr. Garbutt. In response to the additional information received, do you understand what that actually refers to legally? Is there any legal information that has been received that may refer to?
Nothing I'm aware of.
I can answer that if you like. There was the other packet of information is what it's referring to, which includes the 2 letters from Anderson Lloyd. That hasn't been provided previously, whilst in our earlier report to ISCOM, it did summarise the findings and draw conclusions from that.
So that additional information contained 2 legal letters, the upshot of which is what? What is a legal import of that? I'm just wanting to understand recommendation 3.
Can I just understand, it was alluded to earlier that the design is only a preliminary, and that it may well be that questions like ones put by Geraldine Tate about the tapering and where it is in relation to the footpath and things like that may be part of that. That's gave them the ability to not design what is. Okay,
so Madam Chair, you understand recommendation 3 to relate to the conditions which might surround what goes into a safety requirements once the rocks are removed.
We're just looking at the provision of access, but also making it safe for everyone on that corner. Several questions have been alluded to. It was saying that the design of 5.7 basically isn't set in stone, but that's an illustrative of it.
But can I take it that recommendation 3 only refers to those issues?
Can I just clarify? Because I have an amendment with Lynn which arises out of some of that information. So
can I explain resolution 3? Resolution 1 and 2 were in response to the previous committee resolutions, and we sat down and said, so how do we give effect to those? But after that meeting and after resolution, there was much information provided. You've been on a site visit, you've now seen the legal opinion, and we couldn't anticipate whether there might be other things that might come out as a result of that, which came after your last resolution, that might mean some of this might change. So the third one was really to reflect that there might be some other additional bits that you wanted to add in or change, that's all. And it's broader than the design of the actual intersection, could be anything. Okay, so it's broader. So we did debate between staff where we just put in recommendation 1 and 2, which gave effect only to the resolution from your last meeting, but knowing that there had been further information provided both in the forums and site visits, we put in the third one to be explicit. Okay. My final question to Mr. Garbutt then, if we were to approve recommendations 1, 2 and 3 today, would we be on legally solid ground in so doing? Would we be open to legal challenge if we were to approve recommendations 1, 2 and 3?
Yes, you can know what 3 means.
Yeah, what I would say is, 3 is inviting you to instruct officers to do something else. I think you need to, if you're going to do that, give some clarity. But 1 and 2, yes, absolutely. I'll be relaxed that that's consistent with the legal position.
So no problem with moving 1 and 2?
Yes.
Has anyone moved 1
I've got a
and 2?
foreshadowed motion or part of the motion which is up on the board that is indicated from Councillor Thompson. It has been moved to second. I really would like to give questions. I'm happy to say that you foreshadowed something as well. I'd like to
foreshadow moving 1 and 2.
Okay.
And see whatever else.
Thank you. I'll note that.
Can I ask a question relating to that?
Not until we've got it moved or put, because and I'm not getting to that point until we've asked questions, if that's all right. I've still got about 8 questions to come. And I'm sorry, they're now not in order. Aaron asked earlier, but he's already asked one lot, so I'm going to carry on to the first timers first. Doug is next.
Mr. Orange, the access through the domain, is that legal?
Through the reserve.
Through the reserve.
It is not legal road, but it is access. That's under the reserve management plan.
So the only actual legal access on that side of the beach is the continuation of Bank Street.
Just to clarify through the chair that whilst Bankway roads are legal roads, there is still a right of access through the reserve, is my understanding.
And that is the only legal access to that side.
Which
Legal road access through the reserve management plan. I understand the access is entitled.
So this is to Mr. Garden. On the plan that was up here before, where the legal road is on 5.6, the legal road there, that lot of land and behind that is subject to lots. As you can see up on the screen in front of us there, an L-shaped lot there. Look up there on that L-shape with the access. See the legal line, see the green access. That's the access through the reserve. So that lot there, if you were to close that road, there's no legal access. The big front doesn't show this one lot here as per title, but it's in two lots. No, it's in two lots. It's in two lots.
I haven't checked the legal status of that land.
So that could restrict us closing the road.
Well, you're not talking about stopping the legal road though. I mean, the legal road will still be there. You're just talking about vehicles can use it or not.
No, we'll have a little bit further down the track and stopping the road.
Well, I don't think anyone suggested that.
Yeah. You couldn't stop legal access to vehicles. Restrict access to that property.
Yeah, you're correct. Yeah, you're impeding access to the property. Yeah, you'd need to consider that at the time of the bylaw if you are going to restrict vehicles as to whether it might have implications for other land titles such as that. Yes, that's a good point.
Just because something is in lots doesn't mean it's in different titles though either.
No, I know that.
Yeah.
What I'm
I appreciate
saying is being
that.
a lot allowed does allow some.
Okay, the next on the list is Neville, followed by Dave.
Thank you, Madam Chair. My questions for Jean and is around the 24 metres of railing. And given the concerns you heard expressed earlier about the possibility of that railing being a safety risk, could you just elaborate, please, on the purpose of the railing and how that would or would not improve road safety?
Sure. So the primary purpose of the side rail, and it's a side rail in the sense that it is not a physical barrier that would protect pedestrians or vehicles, etc. It's there for the site purpose of visibility. The intention of the site rail in this case is to prevent parking along the edge of the road so that pedestrians would still have a footpath rather than having to go around vehicles onto the carriageway.
Right, and just to follow up, in terms of its placement, as we see it superimposed on the photograph, that would suggest that one part of it anyway wraps around one of the rocks there, and I'm just wondering whether there's, do you think, the scope for a setback of that railing to increase the space for pedestrians?
Yes, there is. This is just conceptual in terms of initial thinking around proposed work. So detailed design will take into consideration some points raised around the width overall to make sure that it is safe.
David, I'm not sure if you wanted a question on that.
Yes, I do. Michael, I just want to pick up on some of Councillor McTavish's questions. Given that Council would want to have safety issues raised with us, and Council would want to take them seriously and would want to identify and address them by whatever process, and you've said or alluded to the fact that there are a number of options in terms of process in identifying and correcting safety issues. Now, you've advised that by law, in the event that we were convinced that there were safety issues,
that a bylaw to close the road would be the appropriate or the best way to go about that. And there are certain rules around bylaws, and you've in your report alluded to some of those. So given that context, given the history of closure, if council wanted to give its process for identification of safety issues, if it wanted to give it the best chance of coming to a robust conclusion, what's the best way forward? Is it recommendations here, or is it something else? If we wanted to get to a point where we could give robust foundation to a bylaw to close the road in the event that we identified safety issues, what's the best way to get there and make sure it sticks?
As I alluded to in terms of my answer to Councillor McTavish, at the moment you don't have a history of use. You can only predict the future, and we're not very good at doing that, but you rely on expert advice. So at the moment you have an expert opinion saying there's a safety issue you need to address. I do consider it would be desirable to add to that actual observations and a track record that the experts can monitor and say, as they're recommending to you, to say we want to monitor this for a period of time to confirm or otherwise the existence of a problem. And as I said in my letter, it seems slightly perverse that to try and identify a safety problem we need to expose people to risk in the interim, but that's the life of an elected member. And the point being that you would put your best, the best evidence would be observation and track record to supplement what we know now. So then at some point in the future to conclude, yes, we have a real problem and the best way to deal with it is to justify a bylaw long term to manage the traffic in that way. So in that sense I do support the approach that it gives you the best position to put yourself in next year to justify a bylaw.
Right, and can you perhaps tease out then what the risks, because there's effectively two options, is to look at it closed and come to some conclusions and use that evidence, or open it and endeavour to get other evidence. If we were to choose the former, i.e. temporarily maintain closure, and what are the process, or are there process risks in that approach in terms of getting a robust outcome?
So if you go down the path of a temporary, and it's a temporary diversion of vehicles, is what you're talking about, you could resolve that today. The caveat I have is that it must be temporary, and within that period then you need to take steps to either fix the problem, reopen the road permanently, or pass a bylaw to permanently close it, and that would allow you some breathing space to go through the exercise of promulgating a bylaw and getting that through the public process. But you will only have the information you have today to justify the bylaw when you come to decide whether it's an appropriate restriction or not, because you'll have nothing else to go on.
And what is the risk of only having that? I mean,
every legal process has risk, and I don't want to overplay that, but what you're dealing with in terms of a bylaw is you are putting out there to the community that currently there is a right to use vehicles on the road, and we want to permanently take that away because of a safety concern. Now, that would be reasonably novel for this council and reasonably novel around the country to do. And what my advice to you is that, and you're not making that decision today, but if you get there, you need to weigh up and decide, is it justified on safety terms to prevent vehicles permanently, or is it more appropriate to take other steps to manage the risk as you might on other roads? And that's a difficult judgment, and one which you could be reviewed on based on the evidence about does the safety concern justify prohibiting vehicles permanently.
Right. So what you're saying when you say that what you could be reviewed on is that effectively theoretical evidence is more open to challenge than actual evidence.
It's not evidence.
Is that
Well, it is evidence. It would be expert opinion evidence, which, you know, we do rely on all the time, but it's not corroborated by actual observation or experience. You know, I would be happier to defend the council's decision to do a bylaw based on opinion plus observation of actual problems. The nagging element of risk inherent in justifying the bylaw based on only expert opinion is that somebody might get another expert to provide another opinion, and then your risk of a successful challenge increases significantly. Now, whether that would ever happen, we don't know, because we haven't been through that exercise. But in response to your question, the best evidence would be supplemented by actual observation and experience and monitoring, in my view. Thank you.
David, you can speak.
Just to tease out that last little bit, please, Mr. Garbutt, and then I'll have to mention Mr. Orenshaw. So, despite your your preference for the perverse steps of exposing people to risk so that you can demonstrate whether there is any, so that you've got a better chance of removing the risk, there's still no impediment. I'm not being unfair, am I? No. There's no impediment, though, to council deciding to continue a temporary closure while some sort of consultation process proceeded around stopping or bylaw or closure or something. In terms of the issues at the time, a long time already elapsed that Councillor McTavish referred to and so on.
Yep. Provided it is temporary. And what I don't want to see happen from the legal process point of view is that you pass a temporary stopping that goes on forever. Because at some point that will get tipped up. So as long as you are clear that if you are going to do a temporary thing, it is for a temporary period, on the basis that steps will be taken to address the thing.
So temporary would cover the length of whatever process that was committed to make a decision about that, and then it was either formalised or opened again.
I would agree with that, as long as that decision is actually in a reasonable time rather than deferred off into the never.
Well, no, I don't think anyone's suggesting the previous
no,
status quo is satisfactory.
That's right.
And if I may, Mr. Orenshaw, the proposals you talk about, and we've seen in previous documents about safety improvements, have you got a dollar figure attached to them?
What was in attachment to the rough estimates of $5,000 for the cycle and science, etc.
Andrew Whiting.
Thank you, Madam Chair. Following on from Mr. Collins and also Councillor Pete's questions about the barrier shown on pages 5.7 and 5.8, is there any thought or indication of clearly or more accurately showing the speed limit of 15 kilometres an hour or encouraging traffic to slow down on that corner?
There's a number of interventions and possibilities. Going back to the resolution that was passed by the committee was to do minor works and minimal works in conjunction with the reopening. And in terms of what's proposed there, that's encapsulated that recommendation or resolution.
Okay. Do we have any other hairpin corners like that? Because that's a pretty sharp corner. Are there any other hairpin corners like that around town? Or would that be one of the slower corners we have throughout the city?
I'm sure there is others. I can't think of specific examples which are similar.
In Warrington?
Every intersection has hairpin corners.
Yeah, but 15 kilometres an hour. Okay.
It's not uncommon to have 15 kilometre corner advisory speed corners.
Okay. And again, I'm not looking at an answer on it, but I just want to put it out there. What speed do you expect someone would exit the track or enter the track in at? Because I can't see them trying to enter it at more than 15 kilometres an hour or exiting it.
If I was to look at the site, I think it would be a relatively low speed exit entry type environment. I think previously there were some concerns raised that, and whether they're valid or not, that vehicles might come up at speed, which would be unsafe because they have boats, etc. on the back that they might be trying to get out of the track, and that was a part of the safety concern.
Okay. was there any previous history of accidents on that corner when the track was open?
On the corner itself, I don't have that specific information in front of me, but I think it's acknowledged that it is an unsafe corner.
No, I agree with that. Okay. And one final question is, when we look at, after attending the meeting on October the 7th out of Warrington, one comment that came through from the locals was that they want no vehicle access and no vehicles on the bay. So following up on page 2.3, the council provides safe access to the beach for vehicles and parking within the Warrington Recreational Reserve, approximately 50 metres from the location of the track. Are there any plans to close any access off those tracks onto the estuary or bay?
So you're referring to the access through the reserves?
Yeah.
Yeah. I'm not aware of any changes to that management plan or intentions to restrict that access.
Thank you.
Councillor Staines?
I have a couple of questions. First one from Mr. Ollenshaw. Just in terms of safety measures to be taken, and the question's been asked before about the 4 metre width, and as I understand it, vehicles tend to be slower if they're going through a narrow passage. And I just wondered whether it would, in terms of engineering, it would be more appropriate to have a narrower egress such that vehicles by nature see a narrow gap and are more likely to approach it at a slower speed. At 4 metres, it's pretty easy to drop a vehicle through at a higher speed. If it came down to being quite a narrow entry-exit, would that have a more beneficial effect on the likely speed of the vehicle?
It's a fair assessment in terms of making the gap wider. They might take it at more speed, etc. But when we're on site, what we weighed up and balanced was that rather than vehicles potentially moving towards the centre of the road to navigate and enter the track, we would prefer that they stay to the left-hand side in that case, so that they were moving off the carriageway more promptly and entering into the track more safely for the balance of the road users. So it's a matter of weighing those concerns.
So potentially you could adjust the entry-exit to force vehicles to enter and exit only from one side?
Yes.
Okay, thank you. The other, just a question of Mr. Garber, in reference to the risk of running on just an expert's opinion in terms of safety versus having some more recorded data. At our last debate, or the one before on this issue, I asked the question whether there had been any recorded injury accidents in the 60 plus years that it was actually open. And the answer to that was not that anybody knew. Is that the kind of data that could be brought in any legal proceedings to make a decision to have it open or closed, to have it open? In other words, the safety, while there might be a perception from engineers on a safety issue, the actual fact that there's been no recorded injury accident might overturn or be in that area.
Yeah, that's exactly right, and I was conscious of that because Mr. Minima referred to that, I think, in his report. So yes, you're dealing with the actual and predictions of experts. So all those things are the evidence that you have, and yes, you need to ultimately justify your bylaw based on the problem, and so it's a question of identifying whether a problem exists.
Thank you.
Okay, without wanting to encourage anyone, we've got 4 questions of repeaters, and I've got some after that. So, Aaron.
Thank you. Questions for Mr. Garber. You referred to the rocks as a council-created impediment, and people aren't arguing, people don't seem to be arguing that the process wasn't faulty. But just to be clear, we don't have an obligation to remedy that historical process error before taking a different course of action.
I think Jared is taking exception to that. So I wouldn't say no one is there.
If you understand my question, I mean, do we have to, if it's currently in the position that we're in now because of a legal process, do we have to remedy that process before we take another course of action? Or can we take the situation now and then take another course of action without going back to that state?
If you were deciding today to pass a bylaw to make the restriction permanent, I think you'd say, well, the restriction, the impediment can remain to give effect to a legal restriction that you've put in place. What I'm telling you from a legal point of view is what is there is not right, and you either remove the impediment or you put in place a procedure to put it right, and that's where I said you can do that temporarily by a resolution or permanently by a bylaw. I'm not going to give you legal advice to say just let it slide, because the legal point of view is that what is there currently is not right, and you, as a responsible council, you need to either put it right or take steps to get it right, in my view.
I mean, we can't pass a bylaw today. The best we could do would begin a process to potentially pass a bylaw. In your opinion, can the impediment remain as long as that process is underway?
I would say that's probably a legally invalid decision, but pragmatic, if you like, because somebody tomorrow could issue proceedings against you and say, get rid of those rocks. And we would advise council don't defend those proceedings because you're going to lose. So from a legal point of view, I would advise you legally, you shouldn't let it slide, you should do something about it. But pragmatically, then if the situation continued for another 6 months while you put in place a permanent order, then it's a risk assessment at a political level about the extent to which you're going to challenge or required to do something.
So even if we decided to temporarily, bear in mind that for all intents and purposes it is currently inaccessible, if we were of a mind to temporarily close it at this meeting to instigate a consultation process around a possible bylaw to stop it permanently, your advice would still be to remove the rocks?
No, I'd be much happier if you resolve to temporarily divert traffic under clause 11 of the 10th schedule. That's a valid decision, which you would then leave the rocks in place because you've resolved properly to temporarily divert traffic. That's okay. The position that I would recommend against is that you make no resolution and just leave the rocks there without having made any proper determination that the traffic be diverted temporarily.
The justification for temporarily diverting traffic, if that was safety or risk, does the decision to permanently stop it, potentially through a bylaw process, have to be made on those same grounds, or is it open to broader factors?
You can justify the bylaw on, let me check that. Yeah, I mean, the ability to pass the bylaw is on slightly broader grounds. You can do it to protect the environment, which brings in the estuary, protect the road, protect adjoining land, or the safety of road users. So those are really the 4 criteria on which you would pass a bylaw.
Right. To go back to your perverse preference for monitoring, you're comfortable with that being the best plan of action, even not knowing what those criteria might be?
That's the best legal strategy, to put yourself in the position long term, if you are looking to promulgate a bylaw, to be able to justify and defend it soundly. Yes.
And in terms of observation of potential safety concerns or risk, would you consider video footage of reckless driving on the wrong side of the carriageway, of which we have been shown many examples at previous meetings? Would that count as observation?
Yeah, you can take into account all evidence, as I've previously said, but I think if you are going to have staff monitor it, you get the proper staff to do a proper traffic monitoring program, so that the person can then give evidence in a proper forum to justify the safety restrictions. But video evidence is always helpful.
Thanks. Richard.
Sorry, just two quick questions. If the rocks are removed, at the moment the track is quite narrow. Does that give the public any right to go in and, I don't know, take a chainsaw to make it more convenient to get the boat up and down?
Not without council permission.
Okay. And my second question, I think is to Jean really. The signage proposed, would there be any impediment in the event that it is open? Would there be any impediment to signage that was more discouraging? In other words, something that said something like, for community safety, vehicles are requested not to use this access, beach access, and parking is available at Warrington Recreation Reserve. Something that at least reduces, I accept that there would be a hardcore of people who are going to assert their right to use this road, but it might at least suggest to most of the public that it would be preferable not to. Is that possible?
Yes, it is.
Hilary, followed by John. It's another list extending, sorry.
I think, Jean, you said that a while ago in answer to somebody on the other side that you didn't know about the actual history, accident-wise and things, and that this was accepted to be a dangerous corner. I thought we'd had some stuff from Ron Minimo or somebody earlier saying that there had been that we knew injuries or whatever on this corner, and this corner doesn't seem to be any more of a danger than a lot of the other intersections around Warrington. So I'm wondering first, how come you didn't know the history about injuries and things if Ron did? And so, I mean, maybe you can clarify that I wasn't hearing you properly. And secondly, when you use the words like this is accepted as a dangerous corner, is that compared with other corners or accepted by whom? Or what? If you're a sort of a roading expert, what's behind the words it is accepted as a dangerous corner?
I'll probably start on the second question. I think when it's accepted as a dangerous corner, it's just due to its environment that it's in. It is, it's got a speed advisory of 15 kilometres an hour, which does indicate that there are risks there and dangers in the right angle corner, just inherent, I suggest. And the second part to that question, I think, Councillor, was yes, there was more around, is there other corners of similar nature and safety hazard? Yes, the city does have a number of other corners which may present a similar safety risk. So back to your first question around the information. Unfortunately, I just don't have that information in front of me right now, and I've relied on staff with the accident history, if it does exist, if there is an accident history, to consider that in terms of the safety advice that's been received.
Is that it, Hilary? I'm feeling like you're wanting to say something else.
Yes.
Yeah. So Ron's evidence or comments that he brought earlier weren't considered by staff? You weren't aware of them? Or?
Yes, we were well aware of them, informing our views on the proposed, in considering the safety concerns. Yes, but Ron was, and his advice and his professional opinion was considered and is a big part of the direction that the council officers have recommended throughout this process.
So just that his comment that there hadn't been any accidents or injuries in the last 60 years, you didn't seem to be responding to the question like somebody who thought that was the position.
Yeah, look, It was probably at that point in my response that I was not 100% certain of whether there was accidents. I had an understanding that the amount of records were very low in that case because it was more of a risk assessment rather than specific accident history. But to categorically say that I would know that level of detail, I wasn't prepared for myself in that position.
Thank you. John?
Michael, you almost answered my question when Aaron asked his just a moment ago. Given the strong submissions from people of Warrington to put a by-law that would make the restrictions legal, I take it from what you said earlier on, it would make their case more difficult if the rocks were left where they are, and I quote you here, because you need to observation of the actual problem with regards to safety. Now, to what degree would that influence someone who was looking at the whole issue? Is it better that the rocks are removed and you can make a strong case for a bylaw? Or can you make a case with the rocks all there? I mean, how much weight is put on that sort of issue?
I suppose I started out answering that question in response to the Mayor in terms of the best evidence, and the best evidence is added by observation and experience, of course. You can make a case based on expert opinion only. I have no doubt about that. It increases your exposure to risk in terms of your process. If somebody ultimately turns up with another expert that counters that view, and as I said previously, whether that ever happens or not, we don't know. But at the moment, you only have Ron's view, and you're entitled to rely on that view as the best evidence you have based on safety at the moment. But the other factors that you do need to consider is the track record of this part of the road, its history, and the accident record are other factors too that go into the mix to evaluate whether preventing vehicles is justified.
Okay, Gerard, you have another question?
No.
Chris, it's going to suggest we'll get through the questions and then we're going to adjourn. But so we've got two more, and I will be asking questions either before or after the adjournment.
Question for Jean. It really relates to what Councillor Hawkins said, and that is that we did see some video evidence of cars cutting the corner as they went round. The question I want to ask is that increasing the risk of having this access way open? In other words, are the cars going to cut the corner more? Are the cars cutting the corner going to provide a risk to a vehicle using the access way? Or is that an irrelevant element in terms of the risk of opening this?
I think, in terms of your question, there's two parts to it. There's the residual risk on the road, on the formed road itself, versus the risk that's on the track. And yes, I believe that by opening the track, that would increase the safety risk.
So more people would cut the corner if the track was open?
Not necessarily cutting the corner. I think that activity is residual. It's there anyway. It's more of the traffic potentially coming out into the path of those vehicles. But
if they were cutting the corner, surely they are further away from those vehicles, because the natural cut is that they'll be further away from that piece which is currently closed. They're less likely to hit the car coming up.
Yes, in
because
terms
they're on the wrong side of the road.
Yes, that would be if the traffic coming down Banks Road was to cut the corner. I was also noticed that traffic on Bay Road also cuts the corner and crosses the line as well on both sides because of the width restriction as well. So I think in essence, that answer your question, yes, there would be an increase in safety risk if the track was open, and to Mr. Collins' question, yes, I had to respond the same way. But the question is, I suppose, what level of risk does that introduce? Does the residual risk that remains on the formed road irrespective of the track?
Jimsy.
So Sorry, I just wanted to understand this, the staff attachment 2, which describes the proposed works, just to follow on from Councillor Thompson's question earlier. It doesn't identify that staff anticipate cutting back vegetation or forming the axis in that annotated diagram. Is it staff's intention to form a 4-metre axis way, or to simply remove the rocks, put in the fence and leave the vegetation and the form the way it is?
That's the intention. There was to be no, from our perspective, there was no changes to the unformed element of the road.
And question of Mr. Garbutt, if there is vegetation over the access way, does that also constitute a council impediment as the rocks legally currently do?
No, it doesn't. You're better off when you manage a road from the liability point of view to do nothing. Once you introduce something, you've got to not impede and take reasonable care. So you don't have to go in and clear vegetation. You can just leave it as an unformed legal road.
Thank you.
Very good. I'm going to propose we have an adjournment briefly. We'll go 2 hours, and I've got a couple of questions that I will ask you, and we'll see where the committee wants to go. Thank you. Welcome back. I just have a couple of questions myself. I just pointed out that I've got an apology for really hard to leave. You can tell me.
No, he doesn't like our decisions.
Just a question. I'm concerned, Jane, about why we're putting the barriers where we're putting them. It has been discussed, but in theory we could put them and put the pedestrian access behind them, couldn't we? Behind barriers and really narrow that street down that it's cars that are going to each other rather than people.
It's a possibility. I think in terms of from some of the feedback we're getting that through the detailed design process, we'd have a closer look at what is a better design for that. And one other option is to simply not install the site rails, that we simply only install the no stopping signs.
Okay. Mike 100, if there is illegal access to this road from each end, which I think there is because of the access to the reserve and onto the beach, which I think is legal access, albeit it's unformed as well. I just want to test my thinking on this. Your view is unless there's two-way traffic, or at least one-way traffic through the road, then we can't do it other than by a bylaw.
Or some other process. Yes, that's right. The right is to pass along the road.
Whichever, but at least in one way.
Yes.
So, whereas we at times may decide to make a road one way, we can do that without a bylaw because it's still providing for a provision along it.
I'm not sure if you've done that without a bylaw. Some of that might well have been done by bylaw.
We've done some without, I'm sure, potentially.
Yes.
Doesn't mean it was proper. Well, maybe.
Well, I don't want to speculate.
No, I don't want to speculate on that at the moment. What I'm trying to work out is what is the legal position of a road that, and just testing you, and I'm trying to think of other examples, but basically your advice is if it prevents a car going through it at any point, unless there's a physical barrier like a cliff or something, obviously we've got no requirement to ramp or anything else or form. But where there is a natural without that natural barrier, people have a right on any paper road to go across it.
Yes, that's right.
Yeah.
And to put in place a impediment to that right is without going through some formal proper process.
Equally, if this had been left alone and had used it for years, and bush had formed, there is no requirement that we form that right away, or that access way. Anyone could go and form that themselves?
Not without council permission.
Not without council permission?
Yes.
And if anyone wanted to cut back vegetation on this site in order to make it wider, better, anything else, they would have to get council consent.
Correct.
Or council officers' consent. But no one can plant there legally either without.
No, they can't. No, it's council property.
Yeah.
So, as with anyone's property, they need to seek your permission. Other than they have the right to pass without asking for permission.
Yeah. Thank you. I think that's me clear. David? I've got a foreshadowed motion which I'll
That's fine. I just want to ask a related question about the comments that Mr. Garbutt just made about the impediments on unformed legal roads. All over the peninsula, there are walkways that are on unformed legal roads, Carrot Track, Peg 41, all sorts, thanks to Bruce Mason. So you were saying, as a result of that comment, that in many areas there are fences blocking them, but they're the only impediment. Walkers have been facilitated by stiles. So any of the four-wheel drive users who felt like taking their GPS and their maps and driving up and down those roads could require the current landowners or the DTC to require the removal of all those fences. And they could then traverse those roads where that's physically possible, which often is. Is that the case?
That is absolutely right from a pure legal point of view, but I would say that the world doesn't often work like that, and the practical side applies, and farmers do get annoyed at that. But yes, legally, you're absolutely right.
Thank you.
And the same as with motorbikes. Yes. As long as they have to keep to the absolute alignment, otherwise they can be trespassing.
Yes, correct.
Thank you. There are no other questions, I think. So the first person to foreshadow a motion was Richard, or their part thereof, and the other one who has foreshadowed anything is now left. So Richard, do you want to take the lead here?
My intention is to move an amendment to the motion rather than...
The recommendation, you mean?
To the recommendation, I should say.
So I just am going to give Tony a chance to explain the situation that he sees it we're in, or do you want me to do that?
I suppose it's, in terms of resolutions, obviously your previous resolution was to open the road, so essentially you need to make a decision as to whether you still want to retain that in terms of opening the road and then what resolutions flow on from that, or you need to make a decision to temporarily keep it closed in accordance with, I suppose, advice from Michael Garbutt and what the resolutions might flow on from that. Some of the resolutions that we've seen depend on what that fundamental question is.
And the recommendations come from the recommendation where we had left it last time.
Yeah.
We are at the situation now, I think, that we can do anything we like. So, Richard, do you want to move?
Well, look, I'm happy. I'll vote against the substantive motion, but I'm happy to move it pro forma. But I primarily want to move an amendment to it.
But you can move it with the amendment if you want to.
Well, then I will move it with the amendment, but foreshadow the fact that
Can I move it?
I'm happy to move it.
Yeah. I'll second it. Chris can move it, and then...
Then we can have an amendment which adds...
Thank you. I think that's fine. Because I put it forward.
Well, it was you and Lee, I think, last time. Okay. Then you're going to ask for an amendment?
Yes.
It's moved and seconded as per the report. Is it 1, 2 and 3?
Yep.
Thank you. Do you want to tweak 3 in light of the advice given by the solicitor?
3 guys. Why don't
You
you
can
tweak
off
they
there.
want to change our mind.
So what's the 1 and 2?
1 and 2. Just
So what we're adding, the proposal is to add...
No, sorry. First of all, let's get the initial resolution by you and Hillary correct. There's the recommendation on page 5.1 is 1, 2 and 3. The lawyers have raised some concerns about 3.
3 is just an advice for
Yeah.
us. Should we just change our mind?
You could take it.
Take it out.
Take it out.
I'm just checking they've moved it, sorry.
Take it out.
I'm seconding one and 2.
Thank you.
Take it out. So it's just one.
Can I suggest that the amendment effectively becomes 3?
Yeah.
Three is asking for amendments.
Yeah.
That's effectively what it's doing.
Okay, I'm just going to do this in absolutely correct form and make sure we all know that we're on the same page. So 1 and 2 have been moved and seconded. I've then got a request for an amendment to that resolution, which is that number 3 be added in, which as per what was up there earlier, it's just coming up together. And then I will ask whether the mover and seconder want to do that or not. Take it as an amendment.
Is it coming?
Yeah,
It's just coming, sorry, don't worry about the pictures.
Just while we're waiting, the purpose of having that map up there was just for illustrative purposes, or was there something in particular that someone thought that we should know about?
This is the area I understand. Yeah? Very well. Yeah. And just there have been suggestions that it was in the ASB area, and I was just using that out and I was trying to find that out.
So do we have an answer on where the ACB is? No.
It wasn't particularly clear.
I was just going to say, can someone point out where the eelgrass is?
Sorry, this isn't, is this a sorry, we take the recommendation that this is the committee agrees. Wait a minute, I don't like the recommendation. Sorry, I appreciate that. Sorry, the first part is the start of that motion, it is recommended that the committee, I don't know that that is note and monitor and then note. That is what we're going to do, and we have the powers here to do this.
As an amendment, does number 3 mean that we do the first steps and then followed by number 3?
Well, I'm just seeking clarification around that because if the resolutions 1 and 2 have, as I read them, the rocks are removed, we do the works that we've talked about, we do some monitoring and we report back in 6 months. So we would see that as a 6-month period where the road remains open when we do that monitoring. I'm unclear as to when resolution 3 would take effect, whether that
Could I clarify that? The whole focus up to now has been around the safety, and I have interpreted the monitoring to be around that. That's what all the discussion is about. If it would make it clearer, then the B could be amended to say monitor this location for 6 months for safety concerns, and then 3 could stand alone.
Okay, I'm just having an issue here process-wise because there is an amendment being put. It hasn't got a seconder yet, but I know that people want to have discussion, and I just want to get the process clean.
The answer to that question is pivotal. Is 3 supposed to happen during that 6 months while the rocks are still there?
That was the intention of my amendment, and the only reason that I'm saying that you might have to monitor B is Mr. Ayres pointed out quite correctly that the 6 months might imply that this happens at the end of the 6 months, and that was not my intention.
Could it finish by saying that submitting to the Infrastructure Services Committee around mid-2015 and report back as in 2 at the end of 3? So it's clear that it comes back in the same process.
Would it be possible to actually just debate the motions that we have rather than complicating it by negotiating wording, and it's only going to make the process about 5 times as long, completely unnecessarily?
Well, then that's what I just wanted some clarity. The problem was we started having a debate without actually having a second for this amendment.
Chair, what I'm suggesting is that I wish to move an amendment, and I'm prepared, and I would make a slight change to that amendment to also be an amendment to B, so that it would add the term for safety concerns, and that's simply for clarity to distinguish it from the substantive purpose of 1.3. And if the mover and seconder are acceptable that that be included, then it can be included. If they're not, then I'll move it and seek a second.
So okay, that's fine, but do you want to put 6 months on yours?
No, because I don't believe that it needs to take 6
months. No, but during that, do you want to say during the 6 months monitoring?
I would be happy to do that, yes.
Could we put that so that during this monitoring period?
So it started on 3. What you're suggesting is that during this 6 months monitoring period, council. Okay? And
so it doesn't mean it has to take 6 months or wait. It's just during this.
Okay, that's been suggested. You are happy to do that?
Chris, are you happy to do that?
I'm happy with the addition of 3 the original resolution which I moved said for a period of 6 months. But I think that says you will wait 6 months. I don't think it has to say you will wait 6 months. I would prefer to see that on this, having had another look at it, for a period of up to 6 months. So if they become, like if it's clear, then we don't sit on our hands for 6 months. If there is a clear safety issue, once those rocks are removed, and our observation shows it, then I think we would expect staff to tell us pretty much as soon as up to 6 months for safety concerns. Richard, do you want to put a timeline on?
I'm just going to have the GM.
Get on.
Can I just have the GM to give advice on that? I'm sorry, there's a lot of people being very patient.
Through Madam Chair, we at a staff level we debated.
Excuse me.
So during the discussion at staff level, we debated how we were going to provide monitoring for this site over a 6-month period. We've outlined a proposal for you. My concern is that if I don't need to raise that, we would anticipate that we may get inundated with local residents' view about how that road is operating as part of that monitoring information, and on what basis do we then judge those bits of information as to whether they are sufficient to warrant bringing a report back. I am concerned from that aspect. If you have it somewhat less than 6 months, I think it leaves that door open, frankly, and I don't quite know how we deal with that, but we tried to put in place monitoring. We looked at whether you can install a camera full-time. That obviously has practical implications around that. So I just signal that as a possible issue if you have open the door for a period of less than a certain period, because I anticipate that is what will happen. And I'm not entirely sure how staff are going to deal with that.
How much will it cost?
Okay.
Money.
A camera?
Sorry.
I don't know, sir. Monitoring. Well, one of the issues for us was to actually suggest a camera that was full-time, but that obviously has a significant cost associated with it. I don't think we costed that.
No, we didn't cost it because sort of came to the view that it was quite a considerable cost, more than what was indicated to sort of intervene in terms of construction and minor improvements.
There are other ways of doing these things, I think, these days. Okay, I'm just going to try and keep to the rules here and no more interjections, please. I've got people who want to talk to it, but I just want to see the mover and seconder happy with 3 and accepting as part of that for the purpose of the debate.
I thought Councillor Vanders was the mover of these.
No, he left. He foreshadowed something completely different, and but he what isn't here.
Well, like Councillor Vanders, I've got some real problems with the process. I think we're just making up this resolution 3. I was very happy with the resolution as it's outlined in the order paper, because it gives the staff the option of being able
That's
to
fine.
look at all different.
Okay, I understand that. What I'm trying to do is get a debate on whether this part 3 is in or out at the moment. At the moment, the mover and seconder are happy with my thing.
I'm lukewarm with that, but I would much prefer the one Councillor McTavish would like to have as 3.
Okay, so that's fine. Then we can get to that point, because I just need something accepted, and then I can discuss it. So the first person to talk to me now is going to be Jinty, if I'm taking that as accepted. Jinty and then Aaron. Jinty?
Thank you, Madam Chair. I would like to propose a further amendment. Should the mover and seconder wish to accept it, then I don't have to move it as an amendment. This is one part of it. There is a second part of it. So this speaks to the issue that Councillor Staines raised in relation to safety concerns, and or I can envisage a scenario where we might have substantial environmental damage overnight, and that may flag up the need to for a report back to Council. So should the mover and seconder be willing to include something of this nature, then I'm happy.
That's your first amendment?
That's my first amendment.
And your second one?
My second one, Lynn, if you could bring up Jinty 1.
You can only deal with one at a time.
Well, they can be accepted both together. Well, she's putting this to the mover and seconder as an option. That's absolutely fine in process.
So this would be instead of Councillor Thompson's 3, and it speaks to the fact that there may be multiple ways in which the significant conservation values of the Blue Sea Estuary might be protected from unsustainable disturbance, that this work be carried out as a matter of urgency, so that prioritises this piece of work and doesn't specify a time frame, and that one part of that piece of work is looking at considering the restriction of motor vehicles by way of a bylaw along the legal accesses to the Blue Sea Estuary.
Okay. So, is the mover happy with that, both those amendments? Because they can be incorporated and then debated.
And I would be happy for my number 3 to fall by the wayside if these were acceptable to the movement.
I'm very comfortable with your first amendment being in the resolution in place of what Councillor Thompson suggested. I think it reads well and it covers some of the issue that I had. But with those last 3, I almost think they might be subsequential to the...
So it would be, those last 3 are effectively a different wording of Councillor Thompson's motion, which is more specific, speaks to a broader range of potential solutions, and puts an urgency around the time frame. So it's not, this isn't instead of 3, this would be additional, so this would be 4. And Councillor Thompson's motion, should you guys wish to accept the 3 that the other 3 that were up there.
So Ginty, motion 1, that was up there before, is in alternative 3, and we'll let's do it A, B and C. So that's A, B and C for an alternative 3, which Richard is happy with. And then the other one is a catch over that if there is a real demand, safety-wise, that we look at resolving it earlier.
So you will have the current 1,
2,
the current 2,
then
you will have 3, A, B, C.
And then 4.
And then 4.
Yeah.
Just as a final bit for 4, where it says bring back to us
Can we just have 2 minutes to put them together, please? So read up here,
see where it says see temporary stopping of the road or other appropriate measure, because they could bring back a response. But it's
just having 2 minutes and we'll get them all up the board. Okay, we've got the agreement for mover and seconder. For this, we don't have to pass. Aaron, you're going to be next one to speak. I'm sorry. I am going to
Andrew.
Sorry, we're just having problems with technology here. Can you please make sure that Lynn's got your amendment? To the fourth motion? Fourth part of the motion? This was never going to be easy, guys.
While we're waiting, Madam Chair, can I just say, through no fault of yours, we've actually got a procedural shambles on our hands here. I mean, but
you didn't keep interrupting.
Sorry, David, we have not, we've got an amendment that's been put. It was accepted by the mover and seconder. We've now moved on to another amendment.
Well, I guarantee that if you asked everyone around the table to write down whatever motion is on the floor, you'd get 14 different.
That's why I'm stopping and getting the whole thing up here. It's an absolutely fair process. Okay. We. Okay, we're about to see if we can get this all on one page as well, which may be stretching the screen. DP there is district plan, for those that are wondering.
Sorry, I've got my. I'm going to lose the first.
Now, because of this, I'm sorry, can I just bear with checking with the staff that this is a dual resolution, workable, because they have to be able to once implement this, and I'm just going to get that consideration. You are happy, aren't you? You're happy? And you're happy, Chris? Okay.
But subject to our legal expert telling us that it's an appropriate thing and we could be happy.
Yeah, all I was going to suggest, we remove it, is maybe you call it a closure / diversion rather than stopping. Stopping
It's a technical term.
is a technical term which causes us to shut it, that's stopping the people.
Thank you.
Just a couple of thoughts. 3A, in order to do that, we'll need to do some work around establishing what conservation values are on the estuary, even though I think there's been various views expressed about that, but we need to be clear on that, which would involve work with DOC, I suspect, and just being clear around that. We need to look at district plan and what provisions are in there. So I understood that might take a little bit of time just to establish that. Because in order to close access, coming back to Mr. Garbutt's advice, we'd need to have a strong case for closing access to a legal road, although that technically, I suppose, isn't on a legal road, that part. So that might take a little bit of time to work through. And I have to express still a concern about number 4 in terms of the time frame, because I believe that we will get reports about the movement of vehicles at that intersection. I'm just a little unsure about how we're going to deal with that, because as part of monitoring, I think we can anticipate that some of the locals will tell us. We might get some more videos as was presented at the public forum at the last meeting, for example, which may result in a report going back to the next Infrastructure Services Committee. So just signal that that is a possibility. I'm just not sure how we deal with it.
Would you think it would be weird and significant when what we mean is we're really concerned, that people's lives are at risk?
Well, I think depending on your point of view and just listening to the various submitters on both sides of this debate, the question of significance is very much in the eye of the beholder. So I'm not, again, it's very difficult for us to judge.
Okay.
So I'm just raising that as an issue. I mean, if there was a set monitoring period, and that is a set monitoring period, that for me just opens up a question of whether the monitoring period is a lot shorter than that, and on what basis does that get triggered? But I suppose we just need to judge that at the time.
Okay, would you like to speak to your motion now, Chris? Very long process, apologies.
It was always going to be a complicated issue to resolve. I think what we have here are a set of resolutions that, while they will not suit everybody's point of view, they firstly correct the situation which we currently have where the road is being closed illegally. That comes with some risk. However, I think it is recognised, and thanks to the other councillors who helped with the additions to this resolution, I think that risk is mitigated by us putting a pretty clear signal there that we are going to take a close look at the safety issues, that if anything becomes apparent, then we will build up a case which will enable us to close that access, close that road in some form, either by law, by bylaw, or by road closure. I personally favour road closure. And that we will start to take into account environmental issues that may stem from inappropriate behaviour of motor vehicles on the estuary. The concern there, of course, is that to fix it, we probably have to close all access to the estuary, because in closing it only in one point, vehicles can still travel around it. So if we're being genuine about it, we probably end up in that situation where we will need to close access to the entire estuary, which I don't think necessarily will be a bad thing. But I think in these resolutions, as I've said, it corrects what is not a legal situation. I think it gives reasonable signal that we have some concerns and are prepared to deal with those concerns if they are proven, and that we will do that in a timely manner. So I think I would urge you to support these. I think it is a good set of resolutions.
Thank you. Aaron, patiently, thank you.
Thank you, Madam Chair. I'm less concerned about the time the monitoring takes than I am about what the monitoring is. You know, we're being asked to approve a monitoring regime that currently doesn't exist, which makes me a little uncomfortable, but not so uncomfortable as I am about safety issues more broadly. And I think when it comes to road safety, we have a responsibility to take the precautionary principle where we can. I can't accept the perverse risks of waiting for something horrid to happen before we're allowed to take our fairly core function with regards to road safety seriously. I think there's sufficient community concern around safety and risk that has been raised to warrant us initiating a process, a bylaw process to temporarily divert traffic, and then begin a bylaw process to look into legally stopping the road, which we do have the option of doing. This isn't our only option. As Councillor Staines has said, we do have the option to temporarily divert traffic and look into legally stopping the road, which then allows us to consider broader environmental and ecological concerns, including our responsibilities under the New Zealand Coastal Policy Statement, the regional plan and our district plan, given it is an area of significant conservation value. And while I have some sympathy for many of the later clauses of the motion, given that they all flow from the fact that we are, in the first instance, removing the rocks and reopening the road, they do little to assuage my concerns in that regard. It is about safety, human safety and ecological safety, and we have the option, and it has been through our legal advice said that this is the best process we have available to us were we to want to leave the council impediments in place in the interim. So I won't be supporting this. I'd like to foreshadow a motion, should this fail, that the committee, in response to safety concerns raised by the community, instruct staff to temporarily divert traffic and begin a bylaw process to legally stop the road.
And I'll second that.
Can I just caution you that you may want to put an access available before you, providing for an access way for pedestrian before you stop, as it's done in the next point. I'm just raising that with you. And then, in the next example, under 6 in the paper, in the agenda. but that's fine, foreshadowed. Thank you. The next one I've got is Andrew Wiley.
I'm sorry, I've got a question. I'm just a little fuzzy on this one. When we're looking at 3C, are we looking at the blue skin estuary as an entirety, or are we just looking at the Warrington portion?
It says points, legal access points to the Blue Skin Estuary.
So the full, all the way around the Doctor's Point?
Have a look at the map on page 5.6.
Okay, do you want to speak to the motion?
Through the chair, that my understanding would be if you refer to the Blue Skin Estuary, you're referring to the physical land from say the Warrington spit, the end of the beach, right round to Doctor's Point. That's the way I read that. Sorry.
It's consideration, I mean, that's
our obligation. On an estuary.
Yeah, sorry, you did.
Well, I was just going to offer as the person that suggested this wording, my intention was to flag up the whole Blue Skin Estuary for consideration. That doesn't necessarily mean that you would go down the track of implementing a bylaw restricting the use of motor vehicles along all legal access points around the Blue Skin Estuary if they are not seen to contributing to 3A, which is protecting the significant conservation values of the estuary. So I think it's just flagging one up for consideration as part of the process.
Okay. Sorry, Andrew, did you want to speak to the motion or you just asked a question? Otherwise I'll go to Richard.
No, I'll speak to the motion. I think first and foremost it's a 15-kilometre-hour corner where traffic safety and safety of all road users is paramount. I think going back to the original proposal to remove the rocks and go for a 6-month period, to me is easily the easiest way to go. I understand some of the other issues coming about, but right from the get-go, Mr. Harbert said what is currently right, what is currently there is not right, and I think that's the bottom line for me, is that we start to remove the rocks and start again.
Okay, Richard?
It was important to me that the amendments got incorporated into this because I sense that it's likely to pass. I won't vote for it, but in the event that it does pass, I think it provides more protection than it did in the form that it started. And the reason that I won't vote for it is because I would prefer to vote for the foreshadowed motion. And my reasons for that are quite manifold, actually. I sense that there's some frustration from one or two people around the table at the amount of time being put into this, but we have a piece of information here that 83% of households contacted there had signed the petition. I think we actually owe it to a community where that percentage of the community is sufficiently concerned about it to take the time to really think about why they're concerned and what that means. And the fact that there is a right, a legal right to access to this piece of track, well, I think there's responsibilities go with rights as well. And I think some of those responsibilities are the questions you should ask yourself. And they include things like, is there another access? How inconvenient is that access? If you want to use this access to get a vehicle down, then by definition you're in it. And how inconvenient is it to have to go about another 60 seconds down the road to use an access that won't upset the rest of the community? I think those are reasonable questions to ask. I accept that the answers to those questions don't determine the legal outcome of this process, but I think that there are other things that do. And when it comes to safety, I asked the question earlier, on what basis will we make this decision? And I'd actually submit that the only evidence that we have in front of us now, and the only evidence that we'll have in front of us in 6 months' time, unless we get lucky and somebody gets hurt, is the evidence that closed it in the first place. The communities don't come and say, take away an access to something on the basis of nothing. They come on the basis of repeated observation and repeated concern. And that's actually the evidence that led to, okay, an incorrect process, I acknowledge that, however many years ago. And frankly, as I say, unless, and I withdrew my term about, drowning witches to see if they're innocent, but that's effectively the same thing here. We've got to see if somebody gets hurt to actually be able to justify it legally. That's nonsense. So the evidence in 6 months' time will be, in my view, the same evidence as it was when they put the rocks there in the first place. And there will not be evidence that can countervail that, just as you cannot prove a negative. So I don't know how staff, this is not criticism of staff, I don't know how staff are going to spend 6 months, unless they sit out there in a deck chair for 6 months, which might be all right through the summer, but and observe what's going on. I don't know how they're going to do that. And secondly, I think we have had additional information brought to us through this process. Initially, my view was, if this is primarily a safety issue, okay, let's look at it that way. But in the presentations that came through the public forum, my eyes were open to some other areas of concern, and I think that there's been further information that's been provided to us in our pack that amplifies some of those concerns. So for all of those reasons, if it's legally possible to do so, and I accept that it may well be challenged, but if it's legally possible to do so, then I would vote for the foreshadowed motion and vote against this. In the event that this motion is passed, at least we have got some further protection in it that I hope will address or allow us to address the concerns that I think are reasonable concerns.
Thank you, Jared.
Okay, well, unfortunately I don't get the opportunity to vote, but I do get the opportunity to speak. I'm going to implore council to listen to the community. And thank you, Richard, Aaron. You obviously have. Legal counsel has given advice that you can temporarily close or redirect traffic at this location to allow a formal stopping process to occur. The resolution that's sitting in front of council at the moment is an ambulance at the bottom of the cliff, not a fence at the top. The damage that could occur will sit with this council. I would also suggest that potentially, with the resolution that's up there, should environmental impact occur, that road safety won't be the reason for the road closure, and that too might be open to challenge. It is imperative that this council signal to our community that you're prepared to listen.
Hillary?
What I like about this resolution is that, in my view, it responds to our obligations and what we would want to do. Our obligations involve following the law, and we have had some legal advice today. They involve following the law not only about road closures and other things we can do with roads, but also about our obligation about the coastal protection of delicate parts of the estuary. And we also should be listening to people. Listening to people who tell us not to obey the law is, in my view, just patently inappropriate. And following a plan that says we know we've done something illegal for many years, and we think we've found a wee legal loophole that says you could temporarily close it using a piece of law that's intended for a short-term safety issue, when we have no evidence that it has a short or even over the last 60-year safety issue of that level, is, in my view, wrong. We do know that council should follow the law, and what we would be saying to people, if we don't pass this but try and close it temporarily, is to say to people, the DCC thinks it's above the law. If it thinks it possibly can sneak its way around it, it'll try and find a way, and this law isn't intended for this sort of purpose. It doesn't follow our legal advice. What we are doing here is showing, and I know some councillors express the view from time to time that we shouldn't be bullied. We should not be bullies either. Best practice here is to follow the law. Best practice here is to get best evidence we can find about what safety issues there actually are on this corner, which we cannot get as a result of leaving those rocks there. They should not have been put there. They are there. They should be taken away. Then we should be looking at what we need to do in a principled way. The precautionary principle here is to, at the very least, follow the law. You can't follow down the path of saying, if there's a possibility one person might be unsafe. The whole of Warrington has these corners, and all of them are unsafe. They're all right angles or T-intersections. The whole lot of them, between anywhere you go and where you go to school, are unsafe. We could say that about any corner. There's nothing particularly different about this one. The other thing that I am concerned about is the idea of listening to new evidence arising today. When I say evidence, I'm not sure that's what it was, but new information arising today that we have not had a chance to test at all. And it's a really bad plan for councillors to listen to something, have an untested view about it, just having had it presented to us and make a decision on it. That's not a good way to go either. We should not show ourselves to be bullies. We should just do what the law says and then listen to the people about safety issues and follow our obligations to the environment.
Andrew?
Thank you, Madam Chair. Picking up on Councillor Calvert's point, firstly I need to say that if everyone followed the law, I don't think there'll be many lawyers around, because we know there are creative ways to argue for and against certain matters. But I firstly also want to mention the importance that my council colleagues have shown with this particular issue and the interest they've taken, and our community certainly appreciates the site visit and all the other information that you've taken on board. And that's fortunate that we've got a council that's prepared to listen, as the chairman's alluded to. I support Councillor Hawkins' approach in terms of this particular issue and what he's foreshadowed. I can't support the removal on the rocks, and my reasons are very much based around the safety issues. And picking up on the legal advice from Mr. Garbutt, it is a political judgment. And in my view, in my time as the ward councillor for the area, this particular issue has been floating around for a long time, and as the documentation in front of us suggests, that there has been conversations and reports to the community board over many, many years, and I'm not prepared to stick my neck out and say something has changed, which means we can take the rocks away and feel relaxed that the safety issue has gone away. That's not the case, and I'm not prepared to do that. And one of the reasons why I'm not prepared to do that is the approach for road safety today is quite different than what it was 10 or 15 years ago. It's very much about prevention, and if you look at Safer Journeys, which is the NZTA blueprint for reducing trauma and death on the road, it's all about prevention. It's all about creating safe driving places or spaces, safe roads, safe vehicles. So I am quite relaxed about having the rocks staying there so that we can ensure that we've still got a safe place. But I also accept that we need to follow due process, and I know that's what Councillor Hawkins is going to move. And I accept that we've done wrong in the past, but we did it for a reason, simply because we felt it was the right thing to do at the time. It was simple, it was cheap, it was effective. It happened within the next few days after the board had made the decision. I'm sure it was once the minutes were noted at council, but it seemed to be a practical and pragmatic solution. So that's my position. I am concerned about some of the other recommendations that follow one, but primarily I support the rocks remaining, and that's my position.
Thank you. Chinty?
Thank you. I think we are in a situation where there is no doubt that the council in the past has followed quality process result of that faulty process. And I can understand the desire of the mover and seconder and others around the table who will probably vote for this to rectify that. However, I can't support 1A and B. The reason for that is because I think that we have had legal advice that there is a way that we can rectify that process in a legal way, in a way that doesn't endanger people and doesn't further endanger our environment from perfectly preventable harm. That is clause 11D of Schedule 10, I think it is, of the Local Government Act. That is a perfectly legal process, and that is entirely open to this council to take, should we wish to, whilst we explore a more final solution. Like Councillor Thompson, the reason I asked for amendments to be made is because I think it probably will pass, and I think it is critical for those who will vote for 1 and 2 that they consider voting for 3 and 4, because it goes some way to ameliorating or mitigating or providing a pathway away from the potential harm that will be done by 1 and 2. There is an argument, and I think it will be made, that by reopening this access track and the result of the monitoring, we will have a stronger body of evidence to support the case for a bylaw which would prevent this accessway being used for vehicles in the mid to long term. However, it's my belief, and I didn't start out with this view, my views initially were around safety, but as Councillor Thompson says, we have increasingly had a number of highly creditable people come to this table or provide evidence saying, look, the environmental issues here are of significant concern. We've heard that from DOC, we've heard that from the Taipure Management Committee, who have to manage this here as part of their work. We've heard it from ornithologists, we have heard it from ecologists, and we have heard it from our own community board, and I thank the chair for making those points that he has today. So in that context, in the context of having such a significant basis of evidence for the environment limb of the section 22AB1G thing within the Local Transport Act, it's my view that the issues around safety and the evidence basis around the safety limb is not as critical as it would be if we didn't have environmental concerns also to back up that case for a bylaw. So whilst I understand the view that some additional evidence might be of use in making that case, I don't think it's critical, and I don't think that the need for that evidence can justify 1A and B and the potential danger that that puts people in Warrington in. So given all of that, I won't be supporting 1A and B. However, I would ask the chair to take them separately. So in the event that 1A and B are passed, I can show my support for some additional amelioration of that potential action by supporting 2, 3A, B, C and D. Sorry, 4.
Thank you. Dave.
Thank you, Madam Chair. I find myself in the position of agreeing with just about everything that Councillor Thompson said, but coming to a different conclusion. I can see all of the sides of this, but frankly none of them convince me completely. If the track were closed, there are other accesses to the estuary. Frankly, if it stayed closed, it's not going to inconvenience very many people at all, and most of the community seem to be wanting it closed. That's the one side. On the other side, I'm not convinced of many of the claims made by the people who want these rocks left there, including their safety claims. And their claims are, in many cases, in my view, tainted by the personal nastiness that underpins half of it. So this is riddled with the claims on both sides, riddled with inconsistencies and irrelevancies. So I find it very difficult to get to the bottom of the facts. So given that nothing's not an option, and given that monitoring in terms of safety was always going to be part of the deal, I've looked at this by way of focusing on getting things legal, determining the safety aspects, and determining a way of achieving the most robust outcome. Now, I acknowledge, as Councillor McTavish has said, that there is an alternative way, and frankly, I will be, if this fails, I will be voting for the foreshadowed motion. My concern is that if we go down the road of temporary closure, it raises the risk of challenge, it raises the risk of drawn-out litigation and this thing going on forever. And I don't know that we are likely to get, and possible failure of the effort to perhaps get a bylaw in place. So that's why I support this means of reaching a conclusion around ascertaining the safety issues, and if they are proven, then putting in place a bylaw that closes this to vehicle access permanently. In addition to that, I support the additional motions which give attention to the environmental issues, and I'll be supporting those as well.
John,
Yeah, look, it's pretty simple.
could you use your microphone, please? Sorry.
Sorry. Yeah, it's been a pretty simple decision for me. I haven't changed my views from day one, or when I got the legal report saying that the rocks were there illegally, and I agree with a number of comments that Councillor McCulloch made with regards to that. So I certainly support 1 and 2. Jared said a moment ago that we should be listening to the residents, and I think we have listened to the residents, and that's why we've got resolution 3 and 4 up there. And I think the residents can take some comfort from that, because if there are safety issues, it would be reported back before the 6 months. If there are environmental or ecological issues that we should be considering, they would be brought back before the 6 months at that stage as well. So we really have got nowhere else to go. We can't disagree with the legal view. That's quite definite, and I think we should go with that. And with regards to the others, as I say, there's an out there, because if they want to, if it's proven there are some safety factors, danger factors before the 6 months, then they can be reported back to the council for our consideration at that time.
Thank you. I've got no other names on my list. Thank you, David.
Thank you, Madam Chair. I have to say I'm a bit amazed at our ability to unnecessarily complicate issues. For me, just like for Councillor Lizette, this is actually quite a simple issue. But what we're addressing at the moment is a motion that actually talks about at least 5 issues that you can isolate. And I'm not sure that's helpful, because as we're seeing in this discussion, lots of people support various bits. And so I hope in due course when this is put in pieces. But the key thing for me is there's actually only one problem here, and that was a problem that was created by council, and that was the illegal placement of rocks, and that does need to be corrected. Since then, however, there doesn't appear to have been any safety issues, and as Councillor Thompson said, the reasons they were put in the first place was because of concerns about safety. We do actually have not just the lack of problems since, as evidence though, we also have in our papers, again repeated today, Mr Milner's expert evidence about safety issues in relation to the track and the corner. So that's on the table in front of us, and we have an overwhelming, if we're to believe what the community board tells us, in the presence of the chair and also the submitters and the documents that have been put in front of us, an overwhelming community view asking for a particular course of action, which is not what this motion proposes. The legal advice we had, of course, does give us a pathway forward, and I'd like to thank Councillor Hawkins for foreshadowing that. But for me, that it's not just perverse to follow the course of action that this suggests, because there is no safety problem now because of council's, albeit illegal, able easily to be corrected action. So if we don't have a problem now, why would we ever consider, as a local authority, potentially creating one and Councillor Thompson's already alluded to the potential for more than perverse outcomes there. I think just to remove the rocks, not proceed with something like the foreshadow motion, is not perverse, it's actually loopy, and I certainly won't be supporting this.
Thank you. Any other speakers? I'm going to just, I think this is a fraught issue, and I think we've all got to that, and I thank you all for your patience today and contributing to what I think has been a very good debate. We've let the community down here by not having a clean process at the start, and I apologise to the community and the community board for putting them through what has been a great deal of angst as well. It hasn't been helpful, and I think the long drawn out nature of it has just embedded views which haven't been helpful. The question to me is, where is the best place to decide this? Is it around this table with the information we've got today, or in an environment where we can look at much broader way than the big picture? I'm almost concerned that we're looking this at only a blue skin estuary issue, when I have brought it up in my previous chairmanship as a city-wide issue about access to the harbours and recreational areas. And in many ways I wish that we were looking at this in Tomahawk and in other areas that other community boards and other communities have come to us with, saying there's an issue here with people having access to cars on beaches and estuaries and how we manage that. Because unfortunately my understanding is beaches above the high tide are roads unless we do something otherwise to prevent that. And I think there's a much bigger issue here which we have failed in the past to tackle. The position is that I don't know that we're in the best position with the information we have to make the decision here today. I think there's a much better process to do that, which would be a bylaw review taking into a much wider gambit of facts we can take into place, into discussion there. And I think I'm veering on the view that we need to do that by having a temporary closure and having all the information on board at a much better level, at a much better level, and veering towards the intended subsequential motion. That takes it away from a lot of the stuff that we've had along the table here today. It also gives some surety to the community that raised a whole lot of issues and we let them down. We didn't go through that process at the time. And that's unfortunate and regrettable, but I think that they need to have had some surety of the process and given some confidence in our intentions at that time as we expressed them, and we need to go with those. I don't think there's anything wrong with that. I'm not favouring which way we go long term. I'm wanting to put into place a process whereby we look at the best way and the best process to fix the situation, preferably right throughout the city, but definitely for this community. So I'm wavering towards the amended motion as the best way of coming to that resolution. Right of reply, Chris.
Councillors, as I said earlier, this was always going to be emotive, and the worst decisions you can make are with emotion. We've heard very emotive statements from both sides of this argument. We've heard some very inappropriate portrayals of some of the people who are involved in this discussion. The thing we lack is facts. There is plenty of talk about perceived safety, and in fact, one councillor, I think Councillor McTavish, made her point that we would gather this data to prove that there was an issue. I would hope we gather the data in order to understand what the issues are and what the appropriate measures are that we need to take to address those issues. If we go on the basis of saying that the amount of information we've got is fact, and we close this access, then we will never know whether we made the right decision or not. And I don't think you can assume that because this access is opened, that the homes are going to tear up the environment, or that there's going to be a huge increase in safety. It's a difficult corner. I don't actually think that at the end of the day, opening this access is going to make much difference to the risks on that corner. However, that does not mean to say that by gathering information we will not get to a position that says there is a real issue here that we need to address, and I'm not so sure, in fact, that a bylaw is the right way to fix it. For me, the right way to fix it, if it's a safety issue, would be to close that piece of the road. Then, and just have it purely for pedestrian access. We have a paper that follows the one that we're debating now, which is exactly that process. If, on the other hand, it is proved to be a significant environment issue, that's a whole different ballgame, because it means consulting or looking at a bylaw, consulting a bylaw that will close all vehicle access to the estuary, and potentially, as Councillor Wilson has pointed out, maybe to all of our estuaries. So I would urge councillors to at least reset the clock. Councillor Wilson has mentioned that unfortunately we haven't done the community well by allowing something to happen which was not legal. But we've equally not been fair on the members of the community who have had this access in the past and have had it withdrawn from them by an illegal means. So I would like to think that we're prepared to reset the clock, that both parties, those for and against, get over the emotion, think about the actual data that we get, and approach the situation in a less emotive and more clear, data-based way. I honestly do not think that we are going to see, other than if we broadcast this widely, come down and use this road and destroy the estuary, I don't think we're going to see much change. And in fact, I would favour that the opening occurred without any new signs and without any protective barriers and with no announcement at all, because I suspect the only person who'd go up and down that track would probably be those people who have used it 8 years ago. So I would urge you to vote in favour of these resolutions. They will, if there is a problem, end up in us taking legal action to resolve it.
Okay, I think we've had a clear indication. We'll now ask, now put the motion. Those in favour, please say. Sorry. Are you calling for that because I can do it? If you call for it, I have to do it. Is that a question, or are you asking me to do it? No? Okay, to call division, putting them in one is there. So we're just doing one initially. I presume it's one together, A and B, not just one A. Okay, one together.
Councillor Benson-Pope.
No. So you take all these resolutions, the whole lot?
I've had a division called, I don't have the choice, we're just doing one. Just one. Just only one.
One A and B.
Yeah.
They were moved by...
All of them have been moved.
Well, I'm going to make a point of order. They were moved by Councillor Staines. I believe that all the resolutions were moved by you?
Yes.
Yes. And it's been called for a division, so we must take them all.
No, we're taking one at a time by division. That's fine. There are a very clear indication earlier on when I said, they corrected me, that we're taking them one, then two, then three. You're calling them separately by division. Okay?
I think it's open for challenge, but it's not.
If you want to challenge it, challenge it.
I'm going forward.
Councillor Calvert. Aye. Your Worship.
Aye.
Councillor Hall.
Aye.
Councillor Hawkins.
No.
Councillor Lord.
No.
Councillor McTavish. No. Councillor No.
No.
Councillor Pete.
Aye.
Councillor Staines.
Aye.
Councillor Thompson.
No.
Councillor Wiley.
Aye.
Councillor Wilson.
No. I've been here before. No.
Motion lost by the chairs.
Okay, we've got an indication for it. Sorry, do you want to do all the other motions? But the two is gone. You, I'm presuming that you want to then put the subsequent motion, or do you want to do two, that we just look at this? 3 and 4 are very hard to hang without...
Yes. They have to be put though.
Okay.
You can't ignore resolutions.
No, the subsequent motion though will go to the substantive matter, which may have 3 and 4 as part of that as well. That's the problem.
We get a clarification on that.
Clarification?
Can you put a subsequent motion before these ones have been put?
These have to be...
That's fine. Do you believe that 2 fails because 1B didn't get passed? Failed? It
turns out we could vote for anything, so what's the vote?
Sorry, does 2B still stand? Because it 1B failed.
2 stand.
So 2.
Well, they're all redundant with the whole lot.
No, they're not. No, they're not. Okay.
They have to be put.
2.
You can put them all together.
2. Do you want to put them together or not? And do 2, 3, and 4, or do
It's fine, together's fine.
all together? We're happy with that? Just taking 4.
You're quite correct, Madam Chair, in my view. Two has failed automatically because of the vote that's just been cast. But the others are quite...
No, 4 relies on 1.
They're
as well.
related, but different issues, and they can be appropriately moved. Well, they've been moved, they can be voted.
Okay. I personally believe 2 has failed.
Well, then it should have been put with 1.
No.
It should have been clarified. We have to clear it up. So let's do it.
3. Okay, we can put 3, A, B, and C.
And maybe we've got to have, Ms. Graham's advice through the mic so that we can understand why we're not voting on 2.
In my view, 2 now fails because you can't have a motion that's in direct contradiction to one that you've just passed. And so because 1 is lost and you've taken them separately, 2 no longer is a valid motion.
4 is equally in there, I think.
But the others are.
3 appears to still be a valid motion. And 4 seems to fail as well.
I think 3 is the only motion. Okay, I'm now putting 3.
Councillor Benson Poe. Councillor Bezet.
Aye.
Councillor Calvert.
No.
Worship.
Aye.
Councillor Hall.
Aye.
Councillor Hawkins.
Aye.
Councillor Lord.
Aye.
Councillor McTavish. Aye. Councillor Noon.
No.
Councillor Peat.
Aye.
Councillor Staines.
Aye.
Councillor Thompson.
Aye.
Councillor Wiley.
No.
Councillor Wilson.
Aye. Okay, now that, I think we now take the subsequent motion that it's failed as it did in principle number 1. You got a motion, Mr.
Indeed.
Councillor Hawkins? You want to... I presume it's a...
Could we know what temporarily means?
During the process of the bylaw?
As long as it takes.
Well, as long as that process takes. I don't think it's...
That might be longer than we leave. That might be longer than we legally could temporarily.
Sorry, yes, we have Andrew seconded earlier. Do you want...
motion report.
Sorry.
I'll see that.
I would really like to support this, but it would need to be on a change. So can I suggest that if we're allowed to be...
Apparently,
You can't say anything.
sorry, can I just get, I just wanted, this means that the mover has no right of, to speak.
Let me just, I just need to check my standing orders because I thought no one could speak.
No, that's right. A procedural motion has been put, which I don't think needs seconded, but I'm just going to, I'm not sure. But I just want to get where it's been done.
I was going to say, it's premature and you're moving the...
Thank you.
I don't know who's allowed to talk to it and say sure. Isn't he the one who's not allowed to talk to it?
Is that a procedural question you're asking, or can I just take it as your...
Procedural question I was asking, once he's asked for it.
You can withdraw any motion that you put at any stage. I'm absolutely sure that
Until it's possible.
Yes, he's withdrawn it. Well, he withdrew it while I was taking advice on it. Technically, my advice is that it could be put, but it's now been withdrawn, so I don't have to worry about that procedural peer review.
In that case, could I ask that the motion be put?
Well, no, because with all respect, before that, there had been an attempt to do an amendment. So, do this in order.
Not since he withdrew his motion. No, you did that before he withdrew.
Yeah, I did it again afterwards.
Thank you. It was foreshadowed. Okay. Sorry. Mayor, you asked to speak to this motion before, just do an amendment.
Yes, can I suggest that there needs to be some wording in there, something like instruct staff to temporarily divert traffic and begin a review as a prelude to a potential bylaw process, because there has to be, we've got to establish grounds, and we need to, personally I think we're at risk if we jump in and say we're going to put a bylaw in place now when we don't necessarily have the evidence to back it up, and I want the staff, in order to get a robust outcome, follow the best process. So I just think we need to follow it properly.
Can I talked to Mr. Garbutt, and I wondered whether instead of begin, it should be investigate a review, because that was the very point that I was going to make. In order to make a bylaw, if there's a legal process you've got to go through to satisfy yourself that the bylaw is the most appropriate means and such like. And having begin a bylaw implies that that is the only thing you're looking at, as opposed to investigate, which we can report back. That technically, that would potentially get it wording right, otherwise potentially it's challengeable, I would have thought.
I'd just suggest investigate and report back to council as to whether
bylaw is the most appropriate.
Bylaw is the most appropriate, because it's ultimately council's decision to kick that off.
Can I ask a question? Is that process that you alluded to not inherent in begin the bylaw process?
I think we need to make sure that the wording of your resolution reflects the words of the Act as much as we can about starting a bylaw process. And so the words are quite specific about investigating whether bylaw is the most appropriate means. Right. So I think to avoid, I suppose, the potential for a challenge around the process at its starting point, defer to Michael Garbutt, but that would be my view.
Yeah, there is a preliminary.
Could we know, considering we're using a temporary divert thing with the intention of closing it, not with the intention of responding to urgent safety needs, how long would we be allowed to use a temporary urgent safety sort of thing for, while we have a look at the bylaw, like for another 6 years, or, you know, because we could be investigating the possibility of something for quite some time, and because they're not connected, you know, the bylaw is one thing, but the temporary road closure, because we've got the safety concern as another, they're not connected, so how could we know whether temporary is within the closure?
my understanding is from the advice we received
Sorry,
earlier that
I was asking for legal advice. Sorry, will you give me?
He asked the question earlier. I think that he was responding from what that question was earlier, Hillary. But since we've still got them in the room, I might as well use the voice.
I think that's what I was telling you, because we've already addressed it in the letter, that it's got to be temporary. What's that? Well, we don't know, but we've said once you get up to and over 9 months, it's risky and arguable territory. So we're thinking preferably 6 months, preferably less than 9 months. You're over 9 months, over a year, you've got potential areas for challenge.
I'm just taking questions on this motion at the moment. I'm not going to allow debate yet because we haven't had the motion.
So should it have time in there?
Ginty, what? Aaron might think about that, Ginty.
My concern is that, given that 3 was passed, which references were considering possible restriction of motor vehicles by way of a bylaw, that this motion would be better to be split into 2 parts. The first part being that the committee, in response to safety concerns raised by the community, instructs staff to temporarily divert traffic from the access way concerned. And the second part, that the work agreed to in 3, previous motion, be expanded to consider safety concerns, given that environmental concerns are covered off already in the review and process that has been highlighted previously in relation to this specific access.
So you're offering that as an amendment, and it's a question of whether the mover and seconder want to accept that as an amendment. That's the process here. Aaron?
my understanding is that when the motion passed 3 doesn't commit to anything in particular if it's looking into a possible process.
No, and I don't think that, I think what the advice is, and Michael will correct me if I'm wrong, but the advice is that council should not be committing to a bylaw before it has identified that that bylaw is the most correct course of action. Which is the means point. So, number 3 specifically did not commit council to a bylaw. It said investigate appropriate measures to protect the significant ecosystems of the Blueskin Estuary. I suggest that any subsequent motion should simply say that we temporarily divert traffic for reasons raised by the community, and secondly, that there is a process gone through that identifies whether or not the bylaw is the most appropriate way to mitigate safety concerns in addition to the environmental concerns raised in 3.
Let's put them both up together so we can see if they read well together.
Wouldn't we have to say what they were? Just to say we're temporarily proposing it for reasons raised by the community.
I'm just wondering whether we'd be better to take 5 minutes to get the wording right and adjournment. Can we just, those that want to participate in, are you happy with that, Aaron, just to get that? And can Aaron, Andrew, Ginty and maybe the mayor get together with that, maybe with Michael? 5 minutes. Thank you. The 4 men have deferred to the 1 female to write it.
It'll be 5 pages long.
Andrew, do you want to read over this one to make sure you're happy first, please? If anyone has any questions? And it'll be input to everything.
So do they change?
No, I'll give you a whole lot of options. There's a bit of black and dogs. I might suggest that the bylaw goes to... Bylaw will be coming to planning and regulatory, won't it? Yep.
Coming to council, and will be heard by commissioners.
I have supervised on that. No, I've supervised that on that. We need to bring it to effect to economics because we need the votes and the council votes. We can't bring it back to the same chairs. working hard on writing this. The up there is 3, which has already been put in past, so that's not part of this. The next part is, I gather, the mover and seconder accepted this amendment. I am now going to ask the mover to speak to his motion. Does anyone wish to speak to this motion? Sorry, Jean would like to address.
The second paragraph of the blue text, the last bit, it only refers to road user safety concerns. Is that narrow, and we are also considering environmental?
That's already been passed in 3A, I think.
That's what's covered. The third part refers back to that. But if we didn't should be encouraged.
Yeah, we wondered if it should just be as the best approach for stop, because the bylaw might be justified on ecological and road safety.
Or to mitigate concerns.
Just seems a bit narrow, potentially.
The best approach to mitigate concerns?
Yes.
Okay.
It might be ecological concerns or stuff.
Okay.
Thank you. Yeah, thank you.
Short is good.
Okay. Hillary, you wish to speak to this?
I do. I just want people to have an understanding when they vote on this that what we're actually saying to the community is that we don't have to follow the law and take the rocks away that we shouldn't have put there, that we have found a way to do it temporarily. We know we're not principled because we haven't even thought about how we're going to take them away at the end of that temporary period if we do anything else. There's no suggestion in this motion that we have any intention to do anything other than ramrod through the moving forward of this by way of bylaw or something. Nobody's even thought about the possible principled position of maybe we might go back to opening the road. So that just reminds us all that this is a bully boy tactic used by the council to do something that they shouldn't have been doing in the first place. Inappropriate, in my view, use of council power. As I say, unprincipled to the extent that there isn't even a plan of what to do if it turns out that there isn't an issue caused by the rocks.
Thank you, Chris.
I'm really concerned about the wording here, because what this says is we are accepting the community's views that there is a road safety hazard here. This is not saying council will investigate whether there are real safety concerns. It's saying here that the committee, in response to safety concerns raised by the community, decide to temporarily divert traffic from the road, and then that the committee requests staff to commence a review to ascertain whether legally restricting. We are immediately assuming that the safety risks there are sufficient, and we need no more data to look for a process to close it. And I don't think that is reasonable, and I cannot support this resolution.
Chris, if it was amended to read that in light of the information already provided in reports by council staff and in response to safety concerns raised by the community, would you then be able to, would you feel more comfortable? Because the council staff in their reports have identified...
I had serious concerns that the case by staff was put together to show that the corner was going to be unsafe with a bias. So I think for me, we need to start again and look at it for real facts and data that do identify that this is a true safety risk. I don't think that has been proven. These resolutions assume that they have.
Okay, Jinty?
Well, I was going to call the point, Madam Chair, but I just think it's unfortunate to assert that council staff have written something in a way that is anything other than their true professional opinion in a public forum, and yeah, I have concerns about that, and
Yeah. Do you want to speak to the motion though, because you are the third person, and that's
I think the fact that your suggested amendment would cover the concerns right now. I think it is a valid concern in relation to the narrowness of what we have covered there. I also think that environmental concerns, given that we have changed part 2 to talk about mitigating concerns. I think that part 1 should also be broadened to talk about safety and environmental concerns. So I would support, Madam Chair, your proposed amendment to refer to the previous stuff.
It's not me to accept that, it's whether the mover and seconder want to take an amendment. It's justification.
Well, I'll move that the question be put.
Motion.
The motion be put.
Procedurally, we've had 3 speakers. Division? Sorry, the procedural motion doesn't need seconding, does it? Sorry. Do I have a seconder? No, fails. Let's the question was to you, did you want to incorporate that, having highlighted the question? Because
well, my immediate reaction is why I voted the way I did was that I recognise there is safety concerns and Councillor Staines has a contrary view. So I understand why Councillor Staines has said what he said, but that is the reason why I voted the way I did, because I wanted to reflect that the concerns that have been raised by the community and the senior traffic engineer, in my view, need to be addressed.
Okay, so the motion is put, just to say it's because of the community. What the suggested amendment that I asked about was whether it should be that the committee, in response to the safety concerns raised by the community and from the information from the staff in the reports already received.
Yes, I'm quite relaxed about that.
Okay. And are you, Aaron?
Yeah, that's fine.
Put it in number 1 and not number 2.
Number 1, sorry. But if we're in response to the safety by the community and foresight. And from information received from staff and previous reports. And what was in the positions.
I was going to suggest that, picking up on Councillor Staines' concern, that in the second paragraph it might read whether legally restricted, first after commence a review to ascertain whether legally restricting the use of motor vehicles on the unforded legal road might be justified, and if so, whether a bylaw under the Land Transport Act is the best approach to mitigate the concerns.
That's really good. Thank you. That's Aaron and Andrew. Thank you. I just need to go through this.
So we'll get to the end of the page, yes.
Yeah. Richard?
No, it's fine. I'm comfortable with what we've done.
Anyone else wish to speak to this motion?
Can I ask that you ask the mover and seconder about the broadening from safety concerns in the previous statement, given that number 2 has now been broadened to speak to mitigated concerns?
Yeah, that's fine.
Right, isn't it done by 3 before? In 1 we've already passed?
Sorry.
No, it's in 1 that the committee, in response to concerns raised by the community and from information received from staff. Yeah, I'm happy with that.
Because both staff and the community raised a range of concerns, some of which were safety.
Sorry.
Can I ask whether anybody wants to have any closure about the temporary road thing, how we reopen it and things again? There's no...
I think this will be done but within 9 months, and if it isn't, it'll be coming back to...
Well, it doesn't have any feeling like that. There's nothing in there that suggests that...
The advice is that it is only temporary if it's 9 months, and therefore that's...
That's our advice as to what legally we can do. Quite clearly, that doesn't necessarily wash with us. Can we have an answer to bring it back to the...
If you'd like to add some words, so the temporary is 9 months, being 9 months, do you want that in there?
No more than 6 would be fine by me.
I'm uncomfortable putting a specified time on it.
if it's no more than 9, and our legal advice is that more than 9 is likely to be inappropriate, I can't see why we wouldn't put an outside limit on it.
No amendment? Okay. No one else wanting to speak? I'm going to put the motions.
Madam Chair, I'm sorry, I'm just seeking clarity around one because safety is still sitting there and the mover, and I'm not sure whether the seconder or not was agreeable to remove the word safety.
Oh, just so it's concern, sorry, raised.
Concerns raised by staff.
Yeah.
Thank you.
Thank you, that rules it. Thank you. I'm now going to put the motions all as one. Are we happy with it? You can. As soon as you ask, it has to happen. As we're standing orders. I'm putting them all together.
Councillor Benson Pope.
Aye.
Councillor Calver.
No.
Worship.
Aye.
Councillor Hall.
Aye.
Councillor Hawkins.
Aye.
Councillor Lord.
Aye.
Councillor McTavish. Aye. Councillor Noon.
Aye.
Councillor Peake.
No.
Councillor Staines.
No.
Councillor Thompson.
Aye.
Councillor Wiley.
No.
Councillor Wilson.
Aye. Thank you all. Right, that's passed. Thank you very much for your patience, everyone who managed to see us way through that. Thank you, staff, and thank you, Michael. Resolution to legalise the Stock Road, Jeff Cott Street, Green Island. You want Michael to chair? You want Michael to chair? Michael, can you chair this, please? This one here? Yeah. I'm sending out. Andrew, the resource consent's already issued. Son? Sorry, there's no point to tell David.
No, he's away.
Okay, I won't chair. John and Jean, any comments? Anyone like to move or say anything about this? Move the motion? Mayor, thank you, Mayor. Seconded, Mike. Any discussion? Sorry, do you want to write to speaking first, Mayor?
No.
You want to write a reply if someone else wants to speak?
No, I don't think I need to do that either. For that very reason. Don't I get off as second?
No.
No.
If you would put your hand up to say you want to speak.
No.
Thank you.
I want to say no.
All in favour, please say aye. Aye. Against? Carried. Thank you very much. Notice of Chair. Matters I'd like to raise, and I'd like community, and I think it does come under you, I'm sorry, don't you? Community and environment. I would like us to be looking at all our vectors and reserves lands as per, if we are going to consider a bylaw for access. And we should be looking more generically than just Blue Skinny Street. I think the wildlife issues and the importance that has to the economic development of the city would justify that approach. So I'm going to throw it to you, and otherwise it might be a collaborative thing with planning and regulatory.
Last time I checked your Madam Chair, this was your notification before you.
I'm appreciate that I'm just throwing it out there under this. Aaron.
Wait, just picking up on the Mayor's earlier point, can we look into the process around having to debate at this committee complying road names?
Yes, there's a road name policy review coming up. Reviewing, so the delegation will be part of that review. Happy with that? Any other matters? Thank you very much for your attendance, and I promise next agenda, hopefully won't be this long.